Better. Okay. Good morning, everybody. My name is Dr. Ron Lewis, and I'll be chairing Panel A of the Medical Board of California. I would ask the people in the audience, please mute or turn off your cell phones in case you haven't done so, and board members here will also be doing the same. In the first order of business, we need to do roll call to make sure we establish a quorum, so would you please call the roll?
Dr. Bishop?
Here.
Judge Feinstein? Here. Dr. Hawkins?
Here.
Dr. Lewis?
Present?
Mr. Warmoth?
Here.
Dr. Yip? Ms. Wright? We have a quorum.
Thank you very much. We have a quorum. Looking at the agenda, still in the open session, the next item of business is the election of panel chair and vice chair. So I open the floor to my fellow members for any nominations for chair. Yes?
I'd like to nominate Attorney Jamie Wright for chair.
Okay, do we have a second?
Second.
Do we have any more nominations? Okay, seeing none, then we proceed with the vote on the chair of Ms. Wright. So we now have to call roll for that.
Dr. Bishop?
Aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Lewis?
Yes.
Mr. Warmoth?
Aye.
We have a vote of yes. Okay, thank you very much. I'm sure she thanks you in her stead. We will see her tonight. She had a conflict, so we'll see her tonight. I'm sure she'll accept, so graciously. The next position is vice chair. So do I open the floor for nominations for vice chair, please? Dr. Hawkins.
I'd like to nominate Dr. Ronald Lewis, vice
Oh.
chair.
I accept the nomination. Second? Second? Do we have any other nominations? Okay, we have another roll call.
Here.
Dr. Bishop?
Yeah, aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Lewis?
I guess, yes, I vote on myself. I don't think I vote on myself, do I?
Yeah.
I abstain. You have to abstain.
Mr. Warmoth?
Aye.
We have a vote of yes. Thank you very much. I'm honored. Hope I could do a good job today for you all. So, and keep the judge in line here as he's asked me to do. So, we've next order of business. And I'd like to introduce our judge, Judge Rory Hewitt, who's with me on my left. So, welcome.
Good morning, thank you.
Yes. Thank you for being here. I'd like to also ask that board members, when they ask questions or make some kind of comment, the court reporter has just asked for us to state our name initially, and then she will later on go around and get the proper spelling. But if you could do that, that would assist her. She would appreciate it, and we all would appreciate that, okay? Is that good? You're welcome. So. The next order of business is the oral argument on a proposed decision, and this is the case of Joanne Marion Benzor, MD. So we ask that the respondent and the attorney and from the AG's office take their appropriate places in the front. I'm not sure which side is which, but you can pick a side, it doesn't matter. Thank you for being here on a Thursday morning. Welcome.
Thank you.
Yes. So the oral argument, thank you very much. The oral argument, I will now turn this over to our judge, Judge Hewitt, who will then proceed with the discussion of this case of Dr. Benzor.
All right, good morning.
Good morning.
And if we could, let me announce the case first. And this is in the case of Dr. Joanne Marion Benzor, Office of Administrative Hearings, case 2016-090-988. And this is the oral argument after non-adoption of a proposed decision. And if I could get the appearances for the record, please.
Deputy Attorney General Trina Saunders, on behalf of the people of the state of California.
And we have Dr. Benzor representing yourself
Yes.
this morning. All right. Okay, and then we're going to go ahead and entertain the oral arguments now. The panel members have received the packets. And so now, and you're stuck with the record. We don't want to go outside the record in terms of any of the argument. And so I'm going to turn it over to Dr. Benzor first, since you are the petitioner in this.
Okay.
Go ahead.
I'm not sure if what I'm going to say is typical for oral argument, but I'm going to do my best.
If it's not, we'll keep you on the straight and narrow.
Okay.
Go ahead.
Regarding my work with Medican that started this mess, I think it was 1999. That was 1 year out of my 29 years of practicing medicine, and it was not at all typical. In fact, I
Let me
would
do this, Doctor. I just happened to think of something. If you'll raise your right hand, please.
Yes.
Do you solemnly swear that the testimony you're about to give in these proceedings will be the truth, the whole truth, and nothing but the truth?
I do.
All right. All right. I just had to remember to swear you in. Usually the attorneys speak, and I forget that sometimes when we have the pro first. I'm sorry. Go ahead.
Okay. As I was saying, that 1 year was not at all typical of my medical career. That job grew out of a need for me to be home more with my 4 kids, and I probably should have kept looking, but it was a job that allowed me to be home when they got home from school and allowed me to, work only on the average 3 days a week, but maintain my income. And I wouldn't call that job practicing medicine. It grew more out of a need. After Proposition 215 was passed, the patients were allowed to use marijuana for medical purposes with a doctor's recommendation, but there were very few doctors that were willing to recommend marijuana to their patients. So companies like Medican sprouted, and their purpose was only to evaluate patients to see if they were appropriate for the use of medical marijuana. The rest of my 28 years in practice was in family medicine. For the first 12 years of my career, I owned Family Medical Clinic of Paris and was sole proprietor and had a couple PAs working under me, and also sublet some rooms in the clinic. And I was there for 12 years and just loved family practice. I still see patients from that clinic. In fact, I ran into a mom and her son who was in his mid-20s about a month ago, and I didn't recognize either one of them, but the mom said, "Look, here's the doctor that saved your life. Show her your scar." And he lifted his shirt, and there was a little vertical scar in the middle of his chest. And this was a boy that came in for his 2-week checkup when he was 2 weeks of age, and was seen by one of my PAs, who after the exam was gathering instruments, and I asked him what he was going to do. He said the baby had an ingrown toenail and he was going to take care of it. And I thought to myself, well, that sounds odd. So I went to see the patient, and he did have a toenail that was kind of pussy around the edges, but the PA had failed to notice that all the toenail beds were kind of dusky. And after further exploration of any other symptoms, the mom did tell me that when the baby cried, blueness would appear around his mouth. So I listened very carefully to his heart and didn't hear any murmur or any abnormal sounds, but nevertheless, he did show some cyanosis around his mouth during the exam. So I called Loma Linda, and they were waiting for him. I had him transported by paramedics, and he had open heart surgery that night.
Excuse me. I'd like to interrupt right here, I'm sorry, because all of this is outside of the record, and
It is.
what happened a month ago certainly couldn't have been part of a record that was made in April of this year.
Correct. You have to stick with the record because the panel members are restricted to reviewing the record in this and then hearing your oral argument on the record. So just confine yourself to addressing the issue as to why you think the proposed decision either ought to be rejected or adopted.
Okay, well, my point was that that year spent with working with Medican wasn't representative of the rest of my medical career. I've gone over why I think those two undercover sheriffs were in fact appropriate patients for the use of medical marijuana. I don't know if you'd like for me to repeat them. One of them was on OxyContin and brought in a prescription bottle, and the physician's assistant did do a symptom based exam by looking at his shoulder, seeing the scar, seeing the decreased range of motion, and saw his prescription bottle with his name on it, and thought appropriately that medical marijuana would help his, allow him to take less of his opiate pain medication. The other sheriff that was given a recommendation had a prescription for Imitrex, whose only indication is for migraine. And I'm sure, as the doctors know, there isn't any physical exam that can confirm the diagnosis of migraine. And so, again, I feel, appropriately recommended the use of medical marijuana. There were also several other undercover sheriffs being seen in that clinic the same day who did not receive recommendations because they weren't appropriate patients. I don't know details. I just know that they were there and they did not receive recommendations. And in fact, about 2 or 3 months after that clinic, both the PA and I were fired by Dr. Talleyrand because we weren't bringing enough income into our clinics. We were taking more time with the patient, and we're not handing recommendations to everybody who came in with their $150. So I was there for almost exactly a year and then returned to traditional family medicine. The violation that resulted in the revocation of my license was getting arrested and convicted of a DUI in 2009, I believe. It's been 7 years, a little bit more than 7 years since that incident. And I had gone out to lunch with a couple of friends at a new restaurant. They didn't have seating to eat, so we sat in the bar and ordered a drink. They had a special on pomegranate martinis, and I had one, and I don't remember it tasting at all like alcohol. About 3 or 4 hours after the first martini, I ended up in Riverside Regional Hospital for a blood draw, and at that time my alcohol level was 0.19. Last night I pulled out the Widmark equation that helps one measure levels of alcohol and how your body metabolizes
Excuse me,
it.
again, something that happened yesterday certainly is outside of the
Sustained.
record.
Sustained, it's outside the record. You're stuck with the record.
Okay. My point was that I'm responding to a statement by the attorney that I should have known that 3 martinis would get me drunk. A usual expectation of a martini, I never had one, but I knew that was probably an ounce or an ounce and a half of alcohol in a martini. Using that equation I mentioned, and extrapolating backwards, in order for me to have blood alcohol level of 0.19 4 hours later,
Objection.
Each
Again,
mar-
this is outside of the record.
Sustained. Yeah, we're not relitigating the underlying offense. so.
okay. But I'm responding to the remarks in her written argument that I should have known that those drinks would get me drunk. And my point was each martini probably had 3 to 4 ounces of alcohol. And sometime during the second one, I started my blackout. Blackout prevents one from forming new memories, so I have no recollection of the following 6 or 7 hours. So it wasn't like I saw any danger of my
Each side is
becoming
limited to 15 minutes.
intoxication.
You have 5 minutes left.
Okay. I am a physician, and that's what I do best. I would like to return to doing that. You know, I thoroughly enjoy the practice of medicine. I have never had any problems with patient care, never had a formal complaint from a patient, never had any malpractice suits brought against me. And I'm just asking the board to allow me to return to the practice of medicine. I'm good at a few other things, but I'm not good at anything more than practicing medicine. And I truly miss it. I don't have a drinking problem, and I don't have a problem taking care of patients, so I don't think there should be any restrictions on my practice when I return. I have a job waiting for me, same job that I was working at when my license was revoked in May of 2012. Been 4.5 years, and that doctor is still waiting for me to return. And am I allowed to ask if there are any questions from you?
Certainly, if you want to entertain questions at this point, we'll certainly allow that.
Yes, I will.
Any questions from any of the panel members? Doesn't appear there are any questions.
Could I ask what led you to issue the non-adoption of the proposed decision?
No, the panel members aren't answering questions. We're just here to gather information at this point. Okay. Let's hear from the Deputy Attorney General, Deputy Attorney General Saunders.
Good morning.
Question, is it possible to ask a question?
Sure, go ahead.
I have a basic question, and that question is, do you accept responsibility for the fact that you knowingly or unknowingly drank too much, and that you did commit a DUI and put people's life, yours and others, at risk at that time? Do you accept responsibility for that?
Oh, yes, I do. Even if I don't have memory of, I realize that was, you know, the horribly dangerous situation that I put myself and others into. And I dislike people who overdrink in general, and I'm just terribly embarrassed that I drank and to the point of blacking out and then got behind the wheel. And I don't drink at all anymore. In the past, I've enjoyed a beer here and there, but I've decided that it's not even worth it to even drink at all. So I do not drink at all.
Okay, thank you. And before we conclude, we'll see if the panel members have any final questions for you,
Okay.
just in case some of the other arguments maybe give them rise to ask a follow-up question.
Okay.
All right, Deputy Attorney General Saunders.
Good morning. Public protection is the highest priority of the board, and in considering reinstatement of this certificate, the board must consider whether or not the public would be at risk. And the people suggest that the public would be at risk, and therefore the penalty should be that the reinstatement petition should be denied altogether. And it would place the public at risk because, based on the record, Ms. Benzer hasn't learned from her mistakes. She hasn't shown recognition that her actions and inactions that are what led to the downfall of her career. Instead, she's blamed others. Remorse for one's conduct and the acceptance for responsibility are the cornerstones of rehabilitation, and that's what's been lacking. She blames everyone and everything, including the board and her finances, for her situation. She doesn't look at herself and demonstrate recognition of the fact that a physician is required to practice medicine within the standards of care within the community. She never acknowledges that such standards are in place for a reason and have to be upheld. She believes her license should be reinstated, but doesn't even see the need or recognize that she needs education or could benefit from conditions to ensure that she practices safely. According to her, much of medicine hasn't changed. Maybe some of the guidelines have, but she specifically states that her ability to give a good physical exam has not. Even if this were true, and medicine wasn't a fluid practice that we know that it is, it was her below standard practice that led to discipline in the first place, and specifically the fact that she didn't provide physical exams. Not only did that lead to an accusation and her being placed on probation, but then her disregard for the medical board and the rules it imposed on her probation is what ultimately led to the revocation of her probation and of her medical license. Her DUI conviction aggravated by the fact that she didn't complete the records-keeping course required, she didn't attend the prescribing practices course that was required, she didn't pay her probation monitoring fees, and did not obey the laws is what ultimately resulted in the revocation. Ms. Benzer is the petitioner. She has the burden of proving rehabilitation and fitness to practice. She has the burden of doing so by clear and convincing evidence to a reasonable certainty. She hasn't done that. In 2006, the board filed its accusation against her for gross negligence, repeated negligent acts, failure to supervise, and failure to perform a good faith examination. Specifically, she was negligent in the care and treatment of 2 patients because a PA saw these patients, did not perform physical examinations, but provided them with prescriptions for marijuana that she pre-signed and gave knowing that they would be given out to patients without examination. In the third instance, she herself saw a patient, did not perform the examination, and gave out the prescription. There hasn't been any acceptance of responsibility or knowingness that this isn't how it should be practiced. Instead, the argument at the hearing was that she knows how to perform a good physical exam. We haven't seen evidence of that. In 2007, based on the foregoing failures to provide the care and treatment necessary for these patients, she entered into a stipulation with the board. She admitted to these things and now backtracks. Ultimately, Ms. Benzer, during the period of her probation, was out with friends, drinking, drank to the point where her blood alcohol concentration was either a 0.18 or 0.19, depending on what part of the transcript you're looking at. Nonetheless, both are 2 times more than the legal limit. And she placed herself and others in danger. And that's what ultimately led to the revocation of her license. At the hearing on the first amended accusation and petition to revoke probation, Ms. Benzer demonstrated that she didn't appreciate the magnitude of her professional misconduct. She minimized the conduct. When testifying about the incident in which her alcohol abuse was exposed, she simply said she was on vacation when she drank and drove and was not a danger to her patients. She indicated that the incident was a one-time deal. It was determined at that time that she wasn't an appropriate candidate for reinstatement or for probation because she didn't seem to appreciate at any level the magnitude of her actions. Now, she petitions to have her license reinstated. She filed her petition package on July 1st, 2015. It consisted of the actual petition for penalty relief, a narrative statement, 2 letters of recommendation, and she submitted an article which she authored and in which she had subsequently published. In that article that she asks the board to consider as part of her package for reinstatement, despite her prior admissions of gross negligence and failing to supervise her physician's assistant, she claims that she was only punished because she didn't have the money to hire an attorney. In the article, she makes light of the board's carrying out its mission of public protection, stating, what are they exactly protecting the public against? The chance that I'll ever recommend medical marijuana to an undercover cop again? 0. The chance that I'll ever overdose on martinis again? 0. This certainly doesn't sound like remorse. Her attitude is one of a person who could care less, and instead of believing the public and patients were aggrieved, she believes she's the aggrieved party and that she's owed something. A hearing on the petition for reinstatement took place on April 28, 2016. Ms. Benzer was the only witness to testify at the hearing. Despite the fact that she had previously admitted to all the causes for discipline and the allegations contained in the accusation, Ms. Benzer attempted to justify the underlying patient care for which she was previously disciplined, stating she doesn't think the gravity of her conduct was as significant as argued, because although there were 5 undercover agents, medical marijuana prescriptions were only given to 2 agents. And despite them not undergoing a complete physical exam, she deems they were appropriate patients for recommendations. She further justifies the lack of care given to these individuals, saying that none of the patients at her clinic were given complete physical examinations. Ms. Benzer goes so far as to say that the physician assistant did a symptom-appropriate physical exam. However, as previously admitted, as alleged in the initial accusation, no exams were performed. The people have evaluated Ms. Benzer's evidence alongside the criteria set forth in Title 16 of the California Code of Regulations, Section 1360.2. in making their conclusions and making recommendations to this board. And the board, too, was charged with evaluating the evidence of rehabilitation submitted by Ms. Benzer, considering the same criteria. Some of that criteria includes the nature and severity of the acts or crime under consideration as grounds of denial. While Ms. Benzer makes light of the actions that led to her license being placed on probation, we find that her pre-signing prescriptions and leaving them with a physician's assistant who's not going to perform a physical exam and then handing them out is significant. We find that herself seeing a patient not providing a physical exam and handing out a prescription is significant. We also find it significant that Ms. Benzer drove with a blood alcohol level more than 2 times the legal limit, was reckless, belligerent, and endangered the lives of others. Another criteria that must be considered is the time that's elapsed since commission of the acts or crimes. We agree that a significant time has passed since Ms. Benzer's license was first disciplined and since her DUI conviction. However, what's alarming is, and even more significant, is the passage of time has not changed her attitude. She's had time to reflect on what's happened. And despite being disciplined by the board, and the board doing all that it could to protect the public and allow for her rehabilitation, she herself doesn't see the actions as significant.
5 minutes remaining.
Another factor that must be considered is evidence of rehabilitation, which was submitted by the applicant, Ms. Benzer. In petitioning the board for reinstatement of her license, Ms. Benzer doesn't take responsibility. She submits the article that I've discussed previously, and she blames the fact that she told the truth and did not have a lawyer for the discipline that she received from the board. Not the fact that she acted outside the standard of care or that she was unprofessional in carrying out her duties as a physician and subsequently irresponsible in the use of alcohol. Ms. Benzer sums up the action against her by stating she lost her license for recommending a safe alternative treatment to a couple of fake patients and for being drunk and foolish once. Ms. Benzer testified that she has kept abreast of developments in medicine. She testifies that in the last 2 years, she's completed 8.75 hours of continuing medical education. But surprisingly, says that this is likely more than she would have done if she were currently licensed. Ms. Benzer testified that she's not in need of education because medicine has not changed significantly since she last practiced. In evaluating this and Ms. Benzer's attitude that medicine hasn't changed very much, one must again question the thing that is very important in a physician, their judgment. This shows a lack of judgment. Ms. Benzer seems to believe that her drinking to the point of being severely intoxicated, such that it caused her to act in a manner that was dangerous to herself and to others, is not a cause for concern for the board because she self-diagnosed herself and determined that she doesn't have a drinking problem. She self-diagnosed that she had a blackout. She hasn't done anything to follow up on that, but says, hey, since I don't have a problem and I've diagnosed it, trust me. She drank to the point that she was intoxicated, belligerent, unruly to law enforcement, and doesn't even remember these things. If nothing else speaks to her judgment as a clinician and the type of clinician the board can expect her to be, this does. The fact that she expects that her self-diagnosis is sufficient. So while significant time has passed since Ms. Benzer's license was first disciplined, it seems that not much about her judgment, attitude, or skill have. Therefore, the public would be at risk by reinstatement of her license, and the board can only surmise that if reinstated, there's a likelihood that she will require further discipline in the future. The people recommend denial of the petition for reinstatement. However, if this board is so inclined to reinstate her license, we do recommend a significant period of probation, a minimum of 5 years. A requirement that she complete the PACE program is a precedent to practicing, that she submit to a psychological evaluation by a board-approved physician and comply with any recommendations that follow, that she complete education in accordance with the disciplinary guidelines, abstain from alcohol, submit to biological fluid testing, have a practice monitor, and be subjected to the standard terms and conditions of probation. Thank you.
Can I,
Thank you. Did you have any of the panel members any questions they have for the Deputy Attorney General?
am I allowed to correct some?
We're going to get rebuttal.
Okay.
You'll have 5 minutes for rebuttal. And as a matter of fact, go ahead.
Okay. There were several inaccuracies by AG attorney. I was compliant with all the conditions of probation. I did take those courses. I believe 1 or 2 of them were not taken right away only because the schedules were full. And I was only able to take certain days off from my work, but I was compliant with all the conditions of probation. I did fall behind on my payments, but that was secondary to financial condition at the time. I wasn't working full-time. I have taken responsibility for my actions, and I believe any physician here would agree with me that medical training includes training on alcohol abuse. it's extremely rare to have somebody in their 50s come into contact with law for the first time if they had a drinking problem. My first rotation as a third-year medical student was in psychiatry, and half of that time was spent being in a residential treatment center for alcoholics and drug abusers. And I'm confident, I'm not self-diagnosing, I'm just stating that there isn't any evidence that I've ever had a drinking problem. And as to her statement that medicine hasn't changed, medicine is changing all the time. What I refer to is physical exams haven't changed. I mean, my ability to do a complete physical exam is the same as it was 5 years ago, and I pretty much pride myself on taking a good history and then doing the physical exam to confirm my diagnosis. And as far as not taking responsibility, I have taken responsibility for everything. I've never made light of the medical board. That article was more or less chronically my experience with the medical board as the mother of 4 kids. She hasn't mentioned that part at all, but that was the gist of the article, not to make light of anybody. As for the CME credits, as you mentioned, of 8, that's not very many. I am very current on advances in medication. Every day I have several medical establishments that send me medical news every day and emails, and during the day I often turn on podcasts or video lectures on
2 minutes
Medscape
remaining.
and other sites, but I haven't actually done the testing, but I am very current on new advances in medication and medicine.
Your Honor,
Any questions?
is it appropriate at this time?
Certainly, go ahead.
Make sure you just state your name for the court reporter.
I shall. It's Catherine Feinstein. Doctor, let me, in reviewing all the entirety of the record, including your testimony and the exhibits and, the letters and the reports, I have just some concern about whether your assurances here today to abide by whatever conditions might be imposed if your license were reinstated with a probationary period. I just look at one document, which I realize may seem a little bit tangential, but you sustained the conviction for a DUI, and that was on September 9th of 2009. Then you are cited for driving with a suspended license on February 7th of 2011.
That was an error in the record, and there should be an amendment from the court stating that wasn't true. My license has never been suspended.
Well,
That you should have the record
there's
in.
another moving violation on December 15th of 2012, and then on September 17th of 2013, not only is there another driving on a suspended license, there's also a failure to maintain insurance, which is required by law.
Okay, those are
And
not,
you failed to appear in court on that as of September 17th, 2013.
those court records are incorrect. And when I had my interview in November of last year with the 2 investigators, I went back to court to clear up those inconsistencies, and they received records that stated that my license had never been suspended, and in fact, those traffic violations were also never happened. I did have one violation for not having my vehicle registered. I was on
I
the
see
way
that.
to get insurance and register it when I was pulled over. And I wasn't working. I had just borrowed money to do all that and was pulled over on the way to do that.
And
But
were
my
you
license was
maintaining-
never suspended.
Were you maintaining auto insurance at that time?
I wasn't driving the car because it wasn't registered, so it wasn't insured, and I was on my way to get it insured before I went to the DMV to register it.
Okay, thank you.
But you should have records of stating that this driving on suspended license was incorrect. My license has never been suspended.
All right, are there any other questions from the panel members? All right, go ahead.
Dr. Ron Lewis. Ms. Menzor, do you understand why your license was revoked in 2012? What is your insight about that?
It was revoked because I violated the conditions of my probation
And those were?
to obey all laws.
Well, I have in the record, I'm reading here, you were given 2 citation orders for failure to abide by the probationary terms. Then you said you finally went ahead and took the classes.
Yeah,
Okay.
it wasn't that long of a time, I don't know. And I cleared everything with my probation monitor.
Okay,
I mean, it should be all in writing that I notified her that the classes were full. I couldn't get in right away. I notified her that I was having problem making the payments. Everything should be in the record.
part of, reinstating a license, I'm just giving you an example, are various terms and conditions. And some of them, we may not feel that is appropriate for our situation, but we as a board feel that we must protect the public, and therefore some of these terms or conditions are how we treat certain kinds of offenses, and we craft them to protect the public. That's our main mission. So my concern about some of the conditions might involve biological testing and refraining from alcohol and require, monitoring of drugs and alcohol. And I'm not quite sure if you understand the gravity of the DUI, the seriousness of the DUI,
Yep.
and the requirement that might be there for a psychiatric evaluation. And could you comment on those probationary terms as it
I would be glad to
Affects you.
adhere to any conditions of probation that are appropriate. I don't mind submitting to biological tests for alcohol. I don't have any history of drug abuse, so not sure why you would want that. I don't know how one DUI would warrant a psychiatric evaluation. I don't have any history of mental illness, of aberrant behavior, nothing to warrant a psychiatric evaluation. If the board requires it, I don't have anything against it. I just don't know that it would provide any useful information. The problems with paying probation costs in the past were due to my not working full-time. My kids were younger. My kids are grown now. I don't have any problem in working full-time, extra hours. In fact, I've already told Dr. Ruiz that I will be available to fill in any clinic that he needs to be filled in. And I don't foresee any problem with being compliant with any conditions that the board places on the reinstatement of my license.
If you're unable to make payment, did you contact the board and try to figure out a payment plan or other alternatives before you let a citation be attached to your record?
Yes, I did. I was in contact constantly with my probation monitor. The only fact that I think may have not, that it doesn't appear in the record is that my probation monitors were changed like every 3 or 4 months. So sometimes information didn't transfer from one to the other. But regardless of who my probation monitor was at the time, I was always in contact with them regarding any problems in fulfilling and being compliant with the conditions of probation.
Thank you. I have no further questions.
Any other questions from the panel members?
And
Yeah.
I cannot stress that
That's okay.
one.
We're going to hear
Okay.
from Deputy Attorney General Saunders now. You have 5 minutes.
Thank you. Petitioner has yet to establish a record of clear and convincing evidence to a reasonable certainty of rehabilitation necessary for reinstatement of her certificate. Therefore, denial of her petition for reinstatement of license is warranted and consistent with the public interest and protection. It's undisputed that a DUI conviction is extremely serious, as was petitioner's conduct when she, as a licensed physician, failed to practice within the standards of care. While we've heard from her and heard about Medican and the fact that it was probably a poor choice of a place to work, the bottom line is that it's her responsibility as a physician to comply with the rules and regulations that revolve around her being licensed and in good standing. The consistent position of the petitioner is placing blame on everyone around her in the situation, whether it be the probation monitor, whether it be the board, whether it be Medican. Where is the self-responsibility? And with respect to either her self-diagnosis or statement of her condition, with respect to drug or alcohol use, as a clinician, she's justified the diagnosis that she made. She states in her testimony that because she grew up in a home with alcoholics and because her behavior doesn't mimic theirs, that she's decided that she doesn't have an alcohol problem. I think an independent reviewer would be a better judge of that, and I think that she should have the judgment and self-awareness to realize that as well as a physician. And the board has given Ms. Binzer an opportunity to conform to and uphold the rules, values, and standards of the community of licensed physicians. Her license wasn't taken away after the first accusation was filed. It was taken away after she didn't comply with the terms and conditions set forth therein. As to the fact that she has the DUI and as to the fact that she pointed out that she did take the classes, Exhibit 5 at page 3, paragraph 14 discusses that she received citations for failing to enroll and complete her medical record keeping and prescribing courses. So even when on probation, she wasn't compliant with the orders of the board. Despite the overwhelming evidence that Ms. Binzer has failed to demonstrate rehabilitation, remorse, or fitness to currently practice, if the board decides to reinstate her license,
2 minutes remaining.
considering that Ms. Binzer has been out of practice for a significant period of time, and she thinks it's a good idea to rely on her past knowledge of medicine as the bar she should maintain in treating patients, she should definitely be subjected to, at minimum, the conditions that the people stated in their initial opening. Thank you.
All right, thank you. Any final questions from any panel members for either the Deputy Attorney General or the petitioner? All right. Very good. Thank you very much. We're going to deem the matter submitted. We're off the record.
Thank you.
Could I ask what the time period is of your decision?
The board will have a written decision out within 30 days.
Okay, thank you.
Okay, good. Okay. We're in open session to hear the oral argument on the non-adoption of the proposed decision on Asghar Egtedar, MD. Did I get that right?
He did as well as I can do on it.
Right.
Egtedar.
Egtedar.
All right, this is, as indicated, a hearing of oral argument on non-adoption of a proposed decision concerning an accusation. Office of Administrative Hearings, case 2016-090-989. And if I could get the appearances for the Office of the Attorney General, please.
Supervising Deputy Attorney General Jane Zach Simon on behalf of the complainant.
All right, and I've had a brief discussion with the board's counsel, and it appears to me that this particular case involves questions of law more so than fact. And basically what it is, just for the public out here, it's a Nevada discipline on a physician's certificate to practice in Nevada. And it's a reciprocity. It's does that form the basis of discipline for California? I've had a talk with the attorney, and in our tentative recommendation to the panel is going to be that the underlying decision was incorrect, the proposed decision, and that it does form the basis of discipline. Upon having that discussion with counsel, the council is going to be recommending, and I've not really looked into it enough to focus on the discipline. But the council feels that this would be an appropriate case for probation, and I think with maybe some conditions precedent, and maybe a psych eval on this one. I'm not sure of the underlying, so I'm just telling the Deputy Attorney General that on the record, so that if you agree that that it is a matter of law, and we're going to find a basis for discipline. I want you to kind of maybe more focus on the nature of the discipline.
I am very happy to hear that, and I think we are tracking along the exact same line insofar as our assessment of this case.
Okay, so I'm just going to turn it over to you, and I'll let you make your argument. There, just for the record, there is no appearance by the respondent or the doctor's former counsel was Albert J. Garcia. In the underlying, we received no written arguments from the respondent or the attorney, so it's a non-appearance by them. We just have the Deputy Attorney General, we have the Deputy Attorney General here, supervising Deputy Attorney General, and we just want to give you this opportunity then to tell the panel exactly what your office's position is.
Our position, I believe, is right along the line of what Judge Hewitt just explained. We do believe that in this case, the Nevada Licensing Board very clearly issued a disciplinary suspension against Dr. Egtedar after it received the results of a neuropsych eval. Now, the law is well established, and I won't belabor it, it's in our briefing, that in out-of-state discipline cases, we take the findings.
Very well briefed, by the way.
Oh, thank you. We take the findings of the out-of-state, of the other jurisdiction, as having already taken place. We are not required, nor is it in the interest of the public safety in California to relitigate or to understand the precise details of how it was that a physician came to take a neuropsych eval, or the precise details of what that evaluation concluded. It is enough under the law that the Nevada board made findings, and I would disagree with the ALJ's characterization of what the Nevada board did. Those were not opinions. They were characterized as findings of the Nevada board, and they made findings that based upon this neuropsych eval they had reviewed, that it was inconsistent with the public safety to allow Dr. Egtedar to practice. So he is.
I agree with that. It would be akin to a criminal conviction, and all of the underlying facts are not as important as the nature of the conviction in some instances.
Yes. And
So it has all the elements, then it satisfies. I agree with you.
So we really are in a position where we have two statutes that allow the board to impose discipline in California. In this case, all we know is that he underwent an evaluation that apparently did not go very well. So we are left to determine what do we do in response. And I've done a number of out-of-state discipline cases for a very long time, and typically, the way we handle these cases is we look at the evidence we have before us, and in this case, it's very little, and we decide what do we have to do in order to ensure that if Dr. Edgar were to come to California, he would not be able to practice until such time as we had taken steps to satisfy ourselves that he could do so safely. In this case, I would suggest that an order consisting of a revocation stayed with a period of probation and a requirement that Dr. Edgar not be permitted to practice medicine until California until such time as he has submitted to and undergone an evaluation by a board-appointed examiner. He should also have a period of where he has to undergo any necessary treatment recommended by the evaluator, and he should have a practice monitor in order to ensure that this person can practice with safety. I would also suggest that a no solo practice provision would be advisable given the extreme nature of a summary probation that still exists in the state of Nevada to this date.
Since we don't know the underlying, would you suggest a PACE evaluation as a condition precedent?
I would suggest that that we don't have any indication that there is a clinical issue here. So I probably would not recommend that. I would say that sometimes in these cases, our experience has been that we will get the evaluation. More often than not, they don't comply with the order. But if we get the evaluation and we determine there are other issues, there is nothing that forecloses us from filing a new action and obtaining whatever other sorts of remedies we might need based on the evidence that we do have. But in this case, at this point, all we know is that there was a neuropsych evaluation. So I do believe that to go far afield from that would probably be inappropriate.
All right. Any questions from the panel members? Go ahead. We'll start with the judge.
I just have a couple of questions, having read this record a couple of times, and I understand what you're advocating as a solution to the problem here. My question is really procedural, and it also goes to the pros and cons of vertical enforcement in my mind. We have a discovery motion that was filed by Deputy Attorney General Brinkman on February 2nd of 2016, and the accusation was filed February 11th of 2016. The hearing was held June 2nd of 2016, and one of the requests in the discovery motion were the results of the neuropsych exam that led to this doctor's suspension in Las Vegas. My question is, during the interceding 4 months between the service of the discovery order and the hearing, what steps were taken to enforce the discovery order?
I don't believe steps were taken to enforce the order. And I will say that we don't vertically enforce the out-of-state discipline cases because typically there is no investigation, independent investigation that is conducted. But we are, in the past year, we are taking steps now that we are being far more aggressive in filing motions to compel discovery and getting them heard and getting an order issued.
Would not our problem have been lessened had some steps been taken in 4 months?
Depending on what the orders would, I think it is a good idea to get that evaluation. And often, in all honesty, it results in a license surrender when we do start doing that. So it does move them along, and it is something that we are taking a look at.
And my second question, if you'll allow me, is I noted in, also in the record that, that the doctor was to have a hearing in Nevada, and that hearing was supposed to be in December of 2015. On his motion, it was continued for 9 months and was scheduled for September 19th, 2016. Did that hearing take place?
I don't know this for certain. It is my understanding that it has not yet taken place. I did check the Nevada Board's website earlier this week, and he remains in, the same order is still in effect in Nevada.
Okay, thank you.
Any other questions from panel members? I think you addressed somebody else's question here, so that's good. I think that's it then. Anything further from the Deputy Attorney General's office?
No, thank you, Your Honor.
All right, we'll deem the matter submitted, and we're off the record. Thank you very much. The court reporter will have a form for you, too, before you head out on us.
We're going now into closed session.
Let us start our afternoon meeting. This is the Medical Board of California Application Review and Special Programs Committee meeting. I'm Dr. Bishop. I'm the chair of the committee. And I'd like now to call this meeting to order. Mr. Warden, will you please call the roll?
Ms. Lawson?
Here.
Dr. Yip? Dr. Bishop?
Here.
We have a quorum.
First, we must take care of a little bit of housekeeping. Are there any public comments on items not on the agenda for today? Seeing none, are there any on the phone? Are we still doing the phone call-ins? Any items from the phone?
We have no questions over the phone lines.
Great. Well, seeing none, let us move along. I will go into closed session. Is that correct, Mr. Warden?
Yes.
All right. Well, let us go into closed session, please.
Good afternoon. Good afternoon. Thank you, Ron. At least we know one person is awake. I want to ask all of us to turn our cell phones to silent and make sure they are off the table so we can avoid feedback noise. You may notice members accessing their laptops during the meeting. They are using the laptop solely to access the board meeting materials that are in the electronic format. This is an official business meeting of the Medical Board of California. As such, disruptions of board's business will not be tolerated. We have a designated time on the agenda for public comment and ask for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I will ask the person to conduct him or herself in such a manner that permits the board to transact its business. This meeting will be available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconference process. For those members of the public participating via teleconference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, press star 1. You will hear a tone indicating you are in the queue for comment. If you change your mind and do not want to make a comment, please press the pound sign. Assistant is available throughout the teleconference meeting. To request a specialist, press star 0. Each person will be limited to 3 minutes per agenda item. During agenda item 2, public comments on items not on the agenda, the board has a limited public comment period for individuals and the teleconference to 20 minutes. In addition, public comment from the individual here at the meeting also be limited to 20 minutes. Therefore, after 20 minutes, no further comments will be accepted. During the public comment on any other item, 10 minutes will be allowed for comments from individuals on the teleconference line and those in the audience. After 10 minutes, no further comments will be accepted. Business Services Office staff will be assisting me with receiving the public comments via teleconference during this meeting. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking an action on any agenda item. If for some reason I forget to ask for public comment on the agenda item, you wish to speak on that item, please raise your hand or come forward and you will be recognized. I would like to request all speakers to complete a presenter slip so I can call you by name at the appropriate time, and that the record of this meeting can be full and complete. However, this is voluntary. Please give the speaker slip to Ms. Toof. Where is Lisa? Okay. Ms. Toof, can you identify you did that already. I don't need to ask you. I'll do my best to call on everyone who has supplied a slip for the agenda item and recognize those who wish to make one last comment. I want to remind all speakers to please stay on the topic and keep your comments to 3 minutes or less. We plan to end meeting at 5:30 p.m. I would like to introduce Christine Lally. Oh, there is Christine. Christine is Deputy Director of the DCA. Welcome. I'd like to call the meeting to the order and ask Ms. Toof to please call the roll call.
Dr. Bolat,
Present.
Dr. Bishop,
Here.
Judge Feinstein,
Present.
Dr. Hawkins,
Here.
Dr. Kraus,
Here.
Ms. Lawson,
Here.
Dr. Levine,
Here.
Dr. Lewis,
Present.
Ms. Pines,
Here.
Ms. Sutton-Wills,
Here.
Mr. Warmoth,
Here.
Ms. Wright, Dr. Gonadev,
Here.
and Dr. Yip. Thank you.
Thank you. A quorum is present. I would like to remind the members again that we'll be taking a roll call vote on all action items. Moving to agenda item 2, public comments not on the agenda. I have one speaker, Mary Ann Hollingsworth. Ms. Hollingsworth.
Good afternoon. My name is Marian Hollingsworth, and I am speaking now as a private citizen, not representing any particular group. I would like to address the issue of conflicts of interest in the medical board panels. I have read many panel cases and decisions over the past couple of years. In a few of those cases, there has been the appearance of a conflict of interest among some panel members. State law says members are to recuse themselves if there is such a conflict. I would like to point out to members of the medical board that it would behoove them to recuse themselves even if there is a perceived conflict, to avoid any question of impropriety. There is also the question about whether panel members should be allowed to vote even with a conflict of interest in order to maintain a quorum. Government Code 11512C states that panel members are required to vote to maintain a quorum. So even if there is an admitted or potential conflict of interest, a panel member is still required to vote. This brings up the issue of whether the member is able to be a fair, unbiased reviewer if a vote is forced. It questions whether the ultimate outcome is valid. Compare this, if you would, to a court case where a judge worked with a defendant, had business dealings with, or was related to him in any way. That judge would be required to recuse him or herself so the final ruling would be credible. That same issue should apply to the medical board, regardless of what the law states. At a time when the board is up for a sunset review, one would hope that all of its actions would be completely above board. I am suggesting that in such cases of possible conflict of interest, the medical board should have a plan in place to have a substitute from a different panel vote on a petition, kind of a switching of places, so to speak, especially when the board knows ahead of time there is a potential for a member to be absent. 11512C even states that, quote, a substitute qualified to act may be appointed by the appointing authority. This way, the question of a conflict of interest would not come into play. The ultimate ruling would be made honestly without the question of secrecy or collusion. By having a full panel without any conflicts of interest, the integrity of the medical board is maintained, the petitioner gets a completely fair review and ruling, and the safety of the public is ensured. I hope you consider this suggestion. Thank you for your time.
Thank you. Any other public comment? Are there any comments on the phone?
We have no questions from the phone line.
Thank you. Let's move to the next agenda item, approval of the minutes from the July 28th and 29th, 2016 board meeting.
Second.
Any comments from the board? Any public comments from the audience? Yes, oh, I'm sorry.
I do have one, I think, error in the minutes under Agenda Item 4, Presentation on the End-of-Life Option Act. I asked Dr. Group that whether or not there were any problems that he foresees. The minutes say that he saw a problem in the Oregon Act. My understanding is that his comment was that a problem in the California Act in that, unlike Oregon, we require 2 independent doctors to okay it, which means that in a small town where you have 2 doctors in practice together, they couldn't do it. So that it limits Californians who live in rural areas from being able to take advantage rather than Oregon.
Mr. Warmoth, I'm trying to see what the minutes shows.
We'll go back and look at that part and make sure that's right. I know he did talk about Oregon actually having problems with access in their state to individuals in areas. You're looking at just let me make sure, you're looking at page 6, paragraph number 3.
Actually, no, it's I'm sorry, I can't find it now, but
Can you tell me what the paragraph
it says, Mr. Warmoth thanked Dr.
Yes.
Grube, and then the next paragraph, which I guess it is on page 6, paragraph 3, I'm sorry, you're
Okay,
correct.
we'll make sure that it's correct.
So we do have a recording, so the staff will look into that and see if it is accurate and what correction need to be done. Any other comments from the board? Any public comment here? Any comments on the phone?
We have no comments. We have no comments from the phone line.
Okay, Ms. Toof, roll call, please.
Dr. Bolat?
clarify the motion that it'll be approved with corrections if necessary upon review of the video.
That's correct.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Aye.
Ms. Wright? Excuse me. Dr. Gonadev?
Aye.
Thank you.
July 16 board meeting minutes are approved with that caveat which we mentioned. Now we'll move to the agenda item 4. That's my report, President's report. First board meeting as the president, actually, even though I chaired a couple of meetings before, but first board meeting. So I really want to thank the board for electing me as the president. And you know that I take this role very seriously, and I'll work with the staff in furthering the board's mission of consumer protection. David Serrano Civil did an excellent job over the past 2 years in leading the board through the several significant, and I hope I continue, significant issues, and I hope I continue to do the good work where he began. In thinking about the upcoming year, there are a few issues that I want to make a priority. The first is the continued fight against the misuse and abuse of opioids, which has led to an epidemic of overdose deaths in California and the nation. While the board has done a tremendous amount of work in this area, including pursuing proactive compliance, I believe there is always more that can be done. I'll be asking the prescribing task force members to meet again prior to our January meeting for brainstorming session to look at some future steps for the board in this arena. I know the staff has been very involved in the statewide work group led by the California Department of Public Health, and I look forward to having an update at the future meeting regarding this work group and the work of the task forces that have been established within this group. As a physician, I continue to believe that a significant part of this issue is physician education, and I will assist in identifying physician groups and organizations where board can provide presentations regarding this issue, educating physicians on the board guidelines and prescribing controlled substances for pain. And I'm looking at the organizations which do this one, like CMA, are the medical staff memberships, and I actually made presentations to a couple already, and I'll continue to do that. My motto always have been, you heard me before, an ounce of prevention is much better than a pound of cure. If we can save one person by educating, that's better than just trying to punish 200 people. The other issue is the board's role is in investigating the inappropriate prescribing of psychotropic medication to foster care children. While this is a much larger issue that involves multiple state and county agencies, the board still has a role to play. The board has already begun to address this issue through its data use agreement with the California Department of Public Health, Department of Healthcare Services, and the Department of Social Services. As you will hear from Ms. Kirschmeyer, physicians who may be inappropriately prescribing to children have been identified, will be investigated as warranted. With the passage of SB 1174, the board will continue to be able to receive data from these two state agencies with the hopes that the board can ensure safe prescribing while also doing what it can to help educate physicians and assist in their willingness to provide services to this population. The issue of patient notification regarding the physicians and probation will also continue to be on the issue that the board will look into over the next several months. I have asked Ms. Kirschmeyer to set up an interested parties meeting in November or early December to discuss what patient notification could look like, taking into consideration the concerns of all interested parties. As indicated at the last meeting, the board takes this issue very seriously and will take up the other issues and ideas in the appropriate standing committees or in the Sunset Review report. Over the next several months, Ms. Pines and I will be reaching out to legislative staff and members to meet with them prior to the board sunset review hearing. We want to ensure that any issues that any member may have are addressed. We will be working with Ms. Kirschmeyer and Mr. Moss through this process. Ms. Pines and I had the opportunity to review the sunset report prior to its release, and we are looking forward to the presentation of this report later today. Ms. Pines and I have had several calls with the board staff to discuss issues and projects at the board, as well as review and approve the board's agenda. We'll continue these calls to ensure board sunset report is delivered as requested on December 1, 2016. In regarding to committee assignment, a copy of the updated committee roster can be found under BRD 5-6 and 5-7. Under the next agenda item, we will be reviewing each board committee to determine if any changes need to be made. Again, I look forward to working with all of you to continue the board's important role as consumer protection as we move through the sunset and of all the other issues before the board. Thank you. Any questions or comments from the members of the board? Okay. Any public comment? Comment on the phone?
We have no questions from the phone lines.
Thank you. Moving to agenda item 5, discussion and consideration of committees and task forces. The board strategic plan states that board should review its committees, subcommittees, and task forces every 2 years to determine if any changes needed to be made. I've asked Ms. Kirschmeyer to briefly go over each committee and its purpose, since we made a significant number of changes to our committees during the last review. No changes may need to be made, but I would like to provide the members the opportunity to review the current committee structures. Ms. Kirschmeyer.
Good afternoon, members. I would like to draw the members' attention to agenda item 5. It's BRD 5-1 through 5-5, and then as Dr. Gonadev stated, 5-6 and 7 are the new committee appointments. Currently, the board has 6 standing committees of the board, 1 council, and 5 two-member committees or task forces that are specific to a certain issue. The standing committees include the Executive Committee, which is listed on BRD 5-1. The purpose of this committee is to oversee the administrative functions of the board. It is the one to receive updates to the strategic plan and to conduct the executive director evaluation. This committee can also meet as needed to review pending legislation if necessary on an emergency basis. The next standing committees are the enforcement and licensing committees found on page 1 and 2. Each of these committees was established to provide expertise and advice to the staff regarding either enforcement or licensing. Each committee is also tasked with identifying improvements and efficiencies as necessary to improve each of these different processes. The Public Outreach, Education, and Wellness Committee is the last standing committee not required in law. This committee assists in the board's outreach plan by providing guidance to staff and overseeing the communication to licensees and the public regarding the board. The next 2 standing committees are actually required by law. The first is the Application Review and Special Programs Committee. This committee reviews applications for licensure and for special program applicants where the board can exercise discretion pursuant to the law. This committee provides a recommendation to the Chief of Licensing, who actually has the final authority for the applicant. The other committee is the Special Faculty Permit Review Committee, which is made up of 2 board members and a representative of each medical school in California. The committee reviews applicants pursuant to Business and Professions Code Section 2168 and provides a recommendation to the board for final approval. The Midwifery Advisory Council is also a mandatory entity, mandated entity that provides advice to the board and guides in discussions regarding the licensed midwives. This council provides recommendations to the board for final approval. Lastly, on pages 4 and 5 are the 2-member committees or task forces currently set by the board for a specific purpose. These groups include the Editorial Committee, who reviews the board's newsletter articles, and that is a yeoman's job, so we have to take our hats off to those members. It takes some time to do that. The Marijuana Task Force, who will be working on the board's guidelines for recommending marijuana for a medical purpose. The Prescribing Task Force, who works to identify a proactive approach to the issue of opioid misuse and abuse. The Sunset Review Task Force, who reviews the draft report and provides guidance to staff. And finally, the newest task force, which is the Midwifery Task Force, who is going to be an advisory body for staff regarding regulations pertaining to licensed midwives. In the document in front of you, it identifies the membership, responsibility, issues, and meeting schedule for each of these different committees. At this time, there is no recommendation from staff to make any changes. Each of the committees is necessary and is relevant to the current activities of the board. The staff recommendation, again, is that you do approve it as provided in the document in front of you. With that, I have any questions?
Move approval.
Second.
Just want to give you one comment. We did take a public member's question into consideration when I made the executive committee appointment. So we have 2 at-large members who are non-physicians. We wanted to balance it out. There was a question about too many doctors on the executive committee. So we took that into seriously. This board functions unanimously most of the time, so we don't have to worry, but we don't even want to have that public perception that something is being done. With that, any comments from the public? Yes, ma'am.
I'd just like to ask Dr. Gnanadev to speak closer into the microphone. Aging ears are having trouble.
Yes, thank you, I will. Any other comments? Any comments on the phone?
We have no questions from the phone line.
Ms. Toof, roll call, please.
Dr. Bolat?
Aye.
Excuse me, Dr. Bishop?
Aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Wormuth?
Aye.
Dr. Gonadev?
Aye.
Thank you.
Next item is board member communications with the interested parties. Any members to anything to report? I just want to make again the same comment. It's important for me because, as I mentioned multiple times, I do wear many hats, including past president of California Medical Association and the AMPAC board and the AMA delegation. So I do meet with multiple leadership of at the state level and the federal level, but we keep the medical board issues completely away. It has nothing to do with my other activities. Yes, ma'am. You still can't hear her.
No, you're doing much better, thank you. I just note that the Midwifery Task Force, as written on that sheet, does not have a licensed midwife on it, and I think we need to have a licensed midwife on the Midwifery Task Force. Thank you.
Ms. Kashmir.
This is a committee of the board. We will have interested parties meetings where we invite licensed midwives to attend those meetings with the task force.
I would like to see that reconsidered. In order to have a task force addressing issues that are relevant and important to the midwives in the state of California, it is thoroughly incomplete without the voice of midwives there. Thank you.
We'll take that into consideration. I'll talk to Ms. Kashmir afterwards. So did we go through? Okay, next item is agenda item 7, executive management reports. Ms. Kashmir.
And I'm going to apologize ahead of time. I actually have quite a long report today just because of a lot of the things that are coming up right now. So. As normal, I will not be going over all of the administrative summary, the enforcement program summary, or the licensing program summary unless someone has a question. Both the licensing and enforcement reports have statistics and highlights of each program in the packet in front of you. However, I do have a few items I'd like to bring to your attention. I'd first like to draw the members' attention to page BRD 7A4, which is the board's fund condition. This document includes complete repayment of the board's outstanding loans to the general fund. As this document indicates, the board's reserve is projected to be at 4.7 months at the end of this fiscal year if the loan is repaid as projected. However, if the loan is not repaid as indicated on the fund condition, on page BRD 7A5, the board will be at 3.6 months reserve at the end of this year. So the first one in your packet on page 4 is actually with all the loans repaid. The one in 5 is without any loans repaid. In addition, without the loan repayments, the board would be below its mandated level in fiscal year 17-18. With the loans, we're not expected to be below that level until fiscal year 19-20. And if you turn to page BRD 7A6, as you may remember, the board did not receive its closing documents for the fiscal year prior to our meeting that was held in July. So the document on 7A6 is the final budget for fiscal year 15-16. And it's actually very important to note that the board spent $3 million more in this fiscal year than the prior year. This increase is due to 3 significant factors. The first is we spent $1 million more in personal services. Again, this is due to a significant decrease in our vacancy rate. As you will remember, over the last several times we've been reporting, our vacancy rate is at 4%, which is incredible for as many positions that we actually have. An increase in our overtime line item also. This year we actually, in our licensing, we had a lot more overtime than we've had to have in years past. And an increase in staff benefits due to the vacancy rate decrease. In addition, the board has several blankets positions, so those are positions that are actually placed in our blanket that it has filled, including the complaint investigation office. The other significant increase was in departmental pro rata, which increased $1.4 million. A large portion of this increase was due to the Breeze project, though, and some of the positions in the change when they put in a new project document. The other large increase was a $1.1 million increase in the Attorney General spending compared to the prior year. With these 3 line item increases, in addition to minor increases in other areas, again, the board spent $3 million more. The final budget in there for 15-16 is the Health Quality Investigation Unit, which is listed on page BRD 7A7. While the HQIU underspent in those personal services due to vacancies, their operating expenses were increased and therefore spending was approximately the same as the prior year. On page 7A8 is the board's budget for fiscal year 16-17. This year's budget was increased due to the increase in the AG spending due to the required reports for SB 467, the additional position in the enforcement unit, and the increase in the expert reviewer line item. So we were able to increase that line item through BCPs. The board staff will carefully review the budget this year to ensure the board is in line with its budget, and we'll continue to monitor that. I also want to let the members know about a change in our reporting of disciplinary action in the board's newsletter. In the summer of 2012 newsletter, the board changed the way it reported information regarding disciplinary actions against physicians. On page BRD 7A20 is a sample of what the prior newsletter summaries included. As you can see, for each physician, it listed a significant amount of information, including the reason for taking action against the physician and also what the specific penalty was. In early 2012, staff proposed changing this because the board now had the ability to link directly to the document, allowing the public to read the complete document to see what action was taken and why. In addition, it decreased the amount of staff time to develop the report. Therefore, beginning in summer 2012, the board changed the reporting that is found on page 7A18. That is now what the new process is that we've been doing, which is a much more condensed report. Over the past few years, the board has had individuals request that the board go back to the previous way it reported information. These requests have come from both the public and physicians, interestingly enough. One of the things the board heard was that physicians didn't know why individuals got into trouble and wouldn't be able to easily see where problems may arise. Therefore, the board began in the summer of 2015 to include a synopsis of what each physician did. However, it wasn't tied to any specific physician. And you can actually see a sample of that on page 19. Upon further discussion with staff, interested parties, and Dr. Gonadev and Ms. Pines, we will be going back to our earlier version of reporting this information. Staff has been notified, and this new version will be included in the winter 2017 newsletter. Since the board had already begun to include the synopsis, the workload will not be too significant. In addition, this will provide information to the public and physicians that they are requesting. Are there any questions before I continue? Okay. I also want to let the members know about a pilot program that is in the process of being implemented. Business and Professions Code Section 853 became effective January 1st, 2003, after passage of AB 1045. This section of law implements the Licensed Physician and Dentist from Mexico pilot program. This law authorizes 30 physicians licensed in Mexico, specializing in family practice, internal medicine, pediatrics, and obstetrics and gynecology, to practice in California for 3 years. The board has to issue a 3-year license to these individuals to practice in a nonprofit community health center. The physicians must be licensed and in good standing in their specialty in Mexico and must be board certified also in Mexico. The physician must have passed the board review course, and those in family practice must also have documented 50 live births and must be in good standing with the American College of OB-GYN. The physicians must also complete a 6-month orientation program that has to be approved by the medical board. They must also participate in an adult English as a second language class and must, after receiving the license, complete 25 CME hours per year. Upon issuance of this license, the physician must also complete a 6-month externship at the health center. This externship program has to be affiliated with a medical school in good standing in California. Complaints against these physicians would follow the same process as California licensed physicians. The facilities where these physicians practice must have quality assurance protocols and either be accredited by Joint Commission or have protocols similar to those required by Joint Commission. The law further states that once the physicians have met the requirements, they can be placed in a pool of candidates to be recruited for employment by nonprofit community health centers in certain areas throughout California. There is also a requirement for this program outlined in law. The board has oversight review of both the implementation and evaluation of this program. The law also requires, though, that this program shall not be implemented until funding for this program has been received from nonprofit philanthropic entities. The board has to report to the legislature every January regarding the status of the program when it is in existence. So for the past 13 years, the board has had different discussions about this program. However, the funding has never been able to be obtained. In recent conversations, it appears this funding may be forthcoming. The interested parties wanting to establish the program have actually met with the board, the governor's office, the Department of Finance, and the Department of Consumer Affairs. At this time, the board has requested authority for a position to run this program should the funding be received. And again, it's contingent only upon that funding coming into the medical board and a fund being set up. I want to bring this to the board's attention because it is not something the current members are aware of due to the fact that this law actually passed, 14 years ago now. Should the funding be received, the board staff will begin to implement the program. The board will also have to work with a medical consultant to review the orientation and externship program. We will provide an update at the next meeting as to the status of this program. But again, I just wanted to bring this to your attention because there's been some talk in the media and there's been some questions about this program. And again, it's something that's unfamiliar with most of us because, again, it has never been implemented. So are there any questions on that?
Dr. Lewis.
Yes, you mentioned that the physicians that are under this program or under this B&P law are subject to discipline the same as a physician that's licensed in California, correct?
That's correct.
So if a physician under this program is disciplined and has a probation for 5 years, 7 years, and the program only lasts, don't they have to go back within a certain period of time, or?
It's only a 3-year program. So we'd probably be looking at that point terminating them.
Terminating
the law
them.
also states that there has to be that they can have individuals in the wings waiting if they terminate one of those 30 to bring someone else into the program.
And you also are, I assume, going to report these types of activities or actions to the legislators in your annual report about potential disciplinary cases.
Yeah, complaints would have to be something that they look at when they're doing their evaluation of the program.
So I just want to make sure that we're protecting everybody with this new program, which we have no experience yet. So, okay, thank you.
Dr. Levine.
So, should this happen, this gives us a rare opportunity to actually prospectively look at the kinds of data we would want to capture in order to evaluate the program.
Yes.
With 30 participants a year, I think we should be looking towards multiple year evaluation, not making judgments on a single year. But I think it's a great opportunity to understand and to put in place beforehand as complete data capture as we can.
Right, absolutely. And the difference, just for those members, the difference between this program and having an individual come in and go through our regular licensure process is that individuals that come in right now and have to meet the requirements of licensure have to undergo 2 years of postgraduate training. And so this allows these individuals to come into California and practice in these areas without any postgraduate training in California or in the United States or Canada, which is unusual. All right, moving on. In regard to cures, as of October 15th, there were at least 74,267,000 physicians registered in Cures 2.0. In addition, there are approximately 32,000 thereabouts who are in Cures 1.0 but have not updated their information, so we can't identify whether they're a physician or a prescriber. So the number actually registered is probably more around 75,000. In addition, as stated at the last meeting, we are still working with DOJ to identify physicians who have a DEA to prescribe but are not yet registered. Once we identify those physicians, we will send emails and possibly postcards to those individuals asking them to make sure that they register. Between September 15th and October 15th, the physicians requested 193,000 reports, which is a 32,000 increase from the last time I reported here at the board. I'm going to be working with staff in the Department of Justice on putting some information on the board's website regarding the usage of cures, and this is something that was brought to my attention by actually Dr. Bishop. Now that individuals are registered, we are finding that many individuals do not know how to use the system. DOJ has some tutorials and other manuals on its website, but it's difficult to find unless you know where they are. We are going to update our website to provide information on patient activity reports and the use of these reports. The board also continues to work with the University of California, Davis and DOJ on a survey regarding the Cures 2.0 system that was sent to all physicians whose licenses expire in November. The survey asks physicians on how Cures 2.0 is working for them and any problems they may have. Again, this survey is part of a study on opioids and part of a grant that was provided to the California Department of Public Health and DOJ. I also wanted to let the members know that I was invited to attend the first National Governors Association Opioid State Action Network call. During this call, an individual from Wisconsin discussed their guidelines that they had just approved in July. There was also a representative from Massachusetts who discussed a recent bill that passed in that state putting restrictions on the amount of opioids that could be prescribed. These calls are focused on best practices between states, and it was a great time to hear what is going on in other states and also discuss what barriers there are to overcome in the opioid misuse and abuse issue. Next, I would like to draw the members' attention to 7E1-3, which provides an update from the Health Professions Education Foundation and the Stephen M. Thompson Loan Repayment Program Annual Report. And this was something, since our two members are no longer on that organization, on that foundation, we continue to put in here. In my report, I provided an update on the issue of overprescribing psychotropic medication to foster care children. As stated, the board received the expert report from the board's expert pediatric psychiatrist who identified numerous physicians who may be overprescribing psychotropic medication. The board has now requested assistance from the Department of Social Services in obtaining the records for these patients. We will be following up next week with the department to check the status of our request. One issue that has come up is that some of the individuals may no longer be in foster care because they are over the age of 18. In those instances, the board will have to locate the individual in order to obtain authorization to receive their medical records. If the board cannot get that authorization, it would have to have enough evidence to subpoena the records. On pages BRD F1 through 11 is a portion of the Bureau of State Audit's report that was released in August on this issue. As you see on page 9, the board had 3 recommendations. On pages 10 and 11 is the board's response to those recommendations, and on page 12 and 13 is the board's 60-day response to that audit report. As you can see, 2 of the recommendations are fully implemented. Recommendation 35 is only partially implemented in that the board cannot investigate the identified physicians until we actually receive the information from the Department of Social Services and the records pertaining to these children. Finally, for the Federation update, I would like to let the members know that on September 30th, I had the opportunity to visit the USMLE headquarters in Philadelphia. I'm on the State Board Advisory Panel to the USMLE, and the annual meeting was held on this day. As you know, the USMLE is the national examination that physicians must pass for licensure. The members heard about recent updates to the USMLE, received information on how individuals are reported to the boards if they had irregular behavior during examination, and reviewed a list of stakeholder issues. The members also discussed topics included in the examination and reviewed the USMLE annual report. I sent a copy of that report to the board members last week, so hopefully y'all received it. The best part of the meeting, though, was the opportunity to observe the USMLE Part 2 clinical skills examination. During this examination, it was just remarkable how organized the exam was. There's been recent talk about trying to get rid of this examination, but after observing this examination, I believe more than ever that this exam is necessary, and this is the clinical skills portion. This is the only time that a physician receives an evaluation of their communication skills. All other examinations are computer-based. The USMLE uses standardized patient encounters during this portion. It was a great meeting, and I'm glad that California is able to be on this advisory panel. And I would encourage any physician members that may be interested in assisting with the USMLE to let me know so I can provide that information to the National Board of Medical Examiners and the Federation of State Medical Boards. The Federation also sent a notice seeking nominations for elected officers. I sent out the information to all members regarding these positions, but at this time I haven't received anyone interested in that. So I'll just move on. The Federation is also seeking individuals who are interested in serving on committees within the Federation. I have only heard from Dr. Kraus at this time, who would like to be nominated to the Ethics and Professionalism Committee and any committee where his expertise can be used. If no one else would like to be nominated for a committee, then at this time I would like to ask for a motion to approve the preparation of a letter of recommendation and support for appointment of Dr. Kraus to the Ethics and Professionalism Committee.
So moved.
Second.
Any comments from the board? Any public comments? Any comments from on the phone?
We have no questions on the phone line.
Roll call, please. Kim, I think you got to do.
All right. Dr. Balat?
Aye.
Dr. Bishop?
Aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Yes.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Sutton-Wills?
Yes.
Mr. Warmoth?
Aye.
Dr. Gonadeb?
Aye.
Thank you. And then lastly, before concluding my report, I would also like to announce some retirements.
Hopefully not yours.
The licensing unit has 2 managers. I'm sorry. That are retiring, that have been with the board for a significant amount of time. One of them you know very, very well. Mr. Shunky will be retiring on November 10th, and Ms. Oseto recently retired last week. We will miss both of these individuals, and we're currently recruiting to fill their positions. Sorry. Finally, I would like to let the members know that Mr. Warden is retiring at the end of the year. Mr. Warden has been with the board for 9 years in different positions, and most recently as the Chief of Licensing. Words cannot express the amount of work Mr. Warden has done for the board and for me personally. I would like to recognize him and ask him to stand. And with that, that concludes my report. I'm sorry, it's long.
Thank you, Kim. And I was about to say, when you mentioned retirements, I said, I was about to say, Kurt, you're not going to retire before I get out of this board. So it's sorry to hear that. I tell you that I haven't met more passionate person than Mr. Warden when it comes to licensing. He knows exactly what's going on, and any young people who has some struggle, we can pick up the phone and call Mr. Warden, and he actually will look into it. And he was always very helpful. So, at the end of the year, next year, right, Kurt? Is that what it is? Yeah, that sounds like right. Any questions for Ms. Kashmir from the board? I just want to, may I talk to Kim, public comment. I think I'm a little concerned about the budget expenses going up. I think we need to seriously look at with some of the changes we did. It looks like the steepness of the curve where the expense is going up is really steep. And we can't sustain if we do that way.
I think it will level off. I think this was just a large jump because everything kind of hit at one time.
Okay, any public comment? I have multiple ones. Lisa McGifford, Mr. McGifford.
Good afternoon. I'm Lisa McGiffert with Consumers Union Safe Patient Project, and I'd like to comment on the part of the report regarding the summaries of disciplinary actions that would give the reason that a physician is disciplined in the newsletter. As you know, it was done in the past, and we're pleased to see that it's being reinstituted. Earlier this year, we worked on legislation that would have required the board to provide these kinds of summaries to help consumers understand why a doctor's on probation and without having to read a long legal document. That work laid the foundation of some recommendations we have for you today regarding these summaries. We would like them to be standardized and written in a patient-friendly, clear, and understandable language. We would like them to include, of course, the reasons the physician was disciplined and any practiced restrictions on that physician's license, because that's an important piece of information for patients, and the duration of the probation if it's about a probation case. In addition to placing this in the newsletter, we recommend that these summaries be included in all communications to the public regarding disciplinary actions. For example, prominently displayed at the top of the physician's profile page on the Breeze website. Currently, one has to scroll all the way down to the bottom to find legal documents on that page, included in the emails sent out when disciplinary actions are taken, and any kind of news releases or things like that. So we appreciate what you've done, and we'd like you to do a little bit more. And as you know, we would like to see patients get noticed when their doctor's on probation, but that is not happening yet. And so this is a way that patients could understand a little bit more about what's going on with physicians. And we want to say we appreciate the changes that have been made on the website, and it continues to improve, making real prominent consumer-friendly language on the homepage, directing people where to look up their doctor, and you've even included a brief video that people can watch, and where to file complaints. I noticed that in the Sunset Report, you reported on a survey that said 1/3 of the people who came to the website and completed the survey were coming to file a complaint. So it's real important for that to be prominent. And we look forward to continuing working with you on improving the kind of information that you provide to consumers. Thanks.
Thank you.
I'm sorry, we actually had a public comment under number 5. Mr. French, I'm sorry, we missed you on that.
Yeah, Mr. French, item number 5.
Good afternoon. My name is Jack French, and we appreciate the balance in the executive committees between public members and physicians. Thank you.
Thank you. Any other public comment on Ms. Kashmar's report? Any comments on the phone?
We have no questions on the phone line.
Okay, so we'll go to the agenda item 8. Update from the Department of Consumer Affairs, Ms. Lawley. Christine, welcome.
Good afternoon, President and members. Always a pleasure to be with you. Christine Lally from the Department of Consumer Affairs, Deputy Director for Board and Bureau Relations. Wanted to start with an update from our directors meeting that we had with our board presidents and executive officers on September 7th. The purpose of these meetings is to update board leadership on the department's activities, as well as share important information and answer questions. Several items contained in my update today will go over key items that we shared with the programs at the September meeting. First, wanted to update the board on one change to our executive team since I was with you at the July board meeting. In May, DCA's Assistant Chief Counsel, Tamara Colson, was appointed as the Assistant Chief Counsel of the Bureau of Medical Cannabis Regulation. Then in August, Governor Brown appointed Ryan Marcroft, who previously served as a Deputy Attorney General at the California Department of Justice. And Ryan replaced Ms. Colson, and we're very happy to have him on board. He's wonderful. Hopefully Carrie agrees. Also wanted to update the board on a recent change to regulations. Review and approval, as you may know, of a fiscal impact statement is required for all proposed regulations prior to submission of a notice of proposed action to the Office of Administrative Law. Since 2009, the Business Consumer Services and Housing Agency has waived this requirement for the boards within the Department of Consumer Affairs. Given an increase in the number of rulemaking packages disapproved by OAL, citing issues of clarity and necessity, our agency has decided to rescind this waiver, and this became effective September 7th. And we did cover this in great detail at our meeting with the executive officers and board presidents. Therefore, prior to noticing any approved regulatory packages to OAL, all DCA boards must first submit them to the department and agency for review and approval. Rulemaking packages should be submitted to Department of Consumer Affairs Legislative and Regulatory Review Unit. We're definitely committed to ensuring this remains a timely process, because we know that additional review, although it has its benefits, can add a little bit of time. We want to make sure that this is a smooth transition for all the boards. So if there's any questions from your executive director or president, please let us know, and we can work with Adam Quinones is the lead on this. He's our Deputy Director for Legislation. Next, wanted to touch briefly on North Carolina case legislation, SB 1194. As you may be aware, SB 1194 was sponsored by Senator Hill, the chair of the Senate Business Professions and Economic Development Committee. This specific legislation contains several provisions to address the antitrust issues presented by the North Carolina Board of Dental Examiners versus Federal Trade Commission U.S. Supreme Court decision that came out in February 2015. The department worked with the Senate BMP committee and various stakeholders to clarify the proposed regulation review process that the department director is involved in. At the Assembly Committee hearing on August 25th, Senator Hill decided to pull this bill from consideration this legislative session. Senator Hill indicated that he would like to convene additional stakeholder discussions to address some concerns raised during this committee hearing. So we'll definitely keep you updated as the legislation gets going again next year. Next, wanted to touch on the Little Hoover Commission, which I'm sure you have heard a little bit about. On October 4th, the Little Hoover Commission released its report, Jobs for Californians, Strategies to Ease Occupational Licensing Barriers. The Commission's report calls for a comprehensive review of the state occupational licensing system, asserting that it increasingly stands in the way of employment and upward mobility, especially for former criminal offenders, veterans, military spouses, and those who are foreign trained and educated. The issue of reciprocity, that is to say, issuing a license to an applicant licensed in another state, is also addressed in the report. Our director, Awit Kadani, recently issued a memo to all of the boards and bureaus regarding the report and provided a copy. He also requested feedback from boards and executive officers, and if you could provide that to us by November 1st. Next, wanted to touch briefly on Sunset Review, which is a hot topic in this room today. On July 13th, the department held its first annual Sunset Review briefing with boards scheduled to go under review next year. This briefing focused on reviewing the Sunset Review timelines as well as the report template provided by the BMP committees. The intent of these briefings is to assist boards with understanding the Sunset Review requirements, provide guidance from executive officers that have already gone through the process, and make the boards aware of all of the resources available at the department, such as legislative and budget offices, to assist with completing the report. And thank you, Kim, for joining us that day. It ended up being a really good training. This morning in Sacramento, the department hosted its annual distributed costs review and open house for executive officers, bureau chiefs, and board presidents. All programs received an overview of the department's budgeting process and pro rata cost distribution. Following the presentations, we hosted an open house where attendees had the opportunity to visit with the department's individual units in order to learn more about the services we provide, as well as meet the individual managers running those units. At today's meeting, the department provided attendees with an updated version of our guide called Distributed Costs and Services, which outlines the budget process, how our costs are distributed to the boards, and the services provided by the department. An electronic copy of this guide will be distributed to all board members in the coming weeks. Wanted to just remind board members, we have our final board member orientation training. You're required to take this training, favorite topic, and Dr. Levine just attended it, thank you. We have our final one coming up on November 16th in Sacramento. So if you are in need of that training, please join us on the 16th, and then most likely our first board member orientation training of the new year will be held in March. But we have our last one coming up, so if you need it, come and join us. Wanted to also update you on the Breeze system. There are 2 upcoming Breeze software releases, and those are coming up November 16th and January 11th of 2017 of the new year. These updates will implement requested system changes by the medical board. And since January 1st of this year, 68 medical board system change requests have been resolved, with an additional 6 set for resolution, with the software releases scheduled to be deployed in November. As of October 14th, there are 61 outstanding requests from the board for system changes that are not yet scheduled for resolution in an upcoming software release. Additionally, our Office of Information Services, that's our IT department at the Department of Consumer Affairs, is working with the State Department of Technology to migrate email services to an Office 365 model. The current platform will be retired in October 2017, so a year from now. The new model includes enhanced features, including increased inbox storage and some social networking to allow collaboration across different departments. Wanted to touch base too this afternoon on DCA's organizational planning and training, which is a really, I think, one of our strongest services and units at the department. You may know it as, it's called SOLID. The department's SOLID Training and Planning Solutions unit is dedicated to organizational development and offers a wide array of services to our boards and bureaus. On September 28th, we sponsored the 3rd SOLID Brown Bag Gathering for our executive officers and bureau chiefs. On this agenda, there was an overview of psychological safe workplaces, building a work philosophy. We also hosted a peer panel and did an update on the Future Leadership Development Program. I had the pleasure of serving on the peer panel with your executive director as well as the executive officer of the Pharmacy Board and State Contractors Licensing Board. And we had a great discussion and had some very interesting questions from other executive officers. So thank you again, Kim, for your always willingness to help your peers. Really, really helpful. And finally, the department is developing a new strategic plan for years 2017 to 2019. And one of the components of this strategic planning process is a survey of our stakeholders. This survey will be distributed to stakeholders, including board members, by next month. We really appreciate your feedback, and it's vital to assist us in improving the department's services. So when you get that email, if there's others that you don't want to open, please open that one, because we really need to hear from the people that we serve, and that's our board members, executive officers, and employees. So, and with that, that concludes my update. Thank you.
Thank you, Ms. Lally. With the review by the DCA on regulations our board comes up with, I gather that's a free service. You're not going to charge us for anything?
Oh, yes, that's part of the pro rata services, correct. You've
Yeah.
already paid.
We think that we're already paying too much anyway, so I just want to make sure that we're not paying any more.
No.
And as far as the Little Hoover Commission, I want you to inform them that with 135,000 licensees, 1 out of every 8 doctors in the country has state of California license. So we're not obstructing, we're just trying to protect the consumer. So we just want to make sure that it's balancing act. We don't have that issue about not letting qualified people in. Any questions to Ms. Lally from board members? Dr. Levine and then Dr. Bishop.
2 comments. The first, while you're right, the notion of mandated training is always a source of grumbling. But I have to say that I attended one this fall, and it was actually excellent, a world different than the last time I attended.
Happy to hear that. Good.
Yeah, and saw some materials that we talked about that I think extremely well done, that would be very helpful to the general public as well as to our licensees about exactly what the Department of Consumer Affairs is. And you talked about potentially making that available on the website. Correct. Really well done materials. My second comment, and I'm raising it here because Kim's tired of me talking to her about it, is that I think going forward, the medical board has decades of information about disciplinary actions that, were that available in a queryable form, it would enable the board and the state to do some predictive work about individuals who come before the board at the time of licensure, relicensure, and at any time of disciplinary action. And our current system of both data capture and what we can extract, the data capture elements that are entered now are just not sufficient to do a good job of this. And so while I understand that no system is perfect, and Breeze certainly has its limits, I think on a long-term basis, looking into how we could merge the data that we know is there into a system that would actually enable predictive analytics about identifying physicians for whom an intervention, a preventive intervention, might make a difference in their career and the safety of their practice. And I realize this isn't a 2016, 2017 issue, but from a systems perspective, I think it's well worth laying out a plan to actually get there someday.
I will definitely bring that back to our IT group, and I know you have a wonderful IT team at the board, so that I think that's something they could look into for sure.
Scope out.
Mm-hmm.
Thanks.
Thank you.
Dr. Bishop.
Yes, a question, and also ask the other board members. I recently received a couple emails about Form 700. Is that going out to everybody now, or is that something new? Are we doing that again already?
I'm not. maybe we could talk offline about the
Okay.
email that you received, but in terms of the Form 700 system, we migrated to an online
Right.
system at the beginning of this year. So,
Yeah, we'll talk offline.
yeah, so as long as you, which I'm aware that you did file on April 1st, the annual filing. If you have your login and password, you should be good to go for the next one next April, but we could definitely work on that. I'm not aware of any emails that went out.
I think we all got them.
Oh, you did?
Yeah, there were, and then there were multiple, right? Yeah. There
Oh.
was an email and a retraction and a clarification.
It seems serious.
It said
Okay.
an account has been set up for you.
Oh,
Right.
Which I thought we did last year.
yeah. Well, now I know. Thank you.
Form 700.
Thank you, Dr.
One
Bishop.
advantage of me is not even looking at some of those emails. Any questions, any other questions? Any comments from the public here?
Maybe those of us who are under suspicion.
Oh,
I should.
mic was off. Any comments from public here? Any comments on the phone?
We have no comments on the phone lines.
Okay, thank you, Ms. Lally.
Thank you very much.
Moving to the next item, big one. Agenda item 9, discussion and approval of the sunset review. Ms. Kirschmeyer and Ms. Robinson.
Good afternoon, President and members. Please turn to Agenda Item 9 for the Board's Draft Sunset Review Report. At the July Board meeting, Ms. Kirkmeyer provided a detailed overview of the Sunset Review process. Board staff from all departments completed their sections of the report. The report was then reviewed and approved by Dr. Gonadev and Ms. Pines. We are now ready to present the draft report and seek your input. Once this draft report is approved with suggested amendments, board staff will finalize the document prior to submission to the legislature by December 1st. This report will serve as a basis for the background paper legislative staff will prepare. A sunset oversight review hearing will be held in early 2017. A few things to note about the report. It has 4 parts and attachments. Part 1 provides information on physicians and makes up most of the written report. Parts 2, 3, and 4 are comprised of other allied health professions. It is organized according to the 12 subject categories of questions provided in the Sunset Review survey document prepared by the Senate Committee on Business Professions and Economic Development. This report is written in narrative form, so the questions are not included. Section 12, Attachment E, contains a copy of the Sunset Review questions. In addition to providing the requested attachments in Section 12, supplementary attachments have been included as specified throughout the report. The report contains various data charts. However, the data charts may not match the Department of Consumer Affairs or the board's annual report data due to the methodology used in getting the information and due to further verification of statistics. I will go over the report by each section, giving you some highlights and ask if you have any questions, comments, or suggest any changes. Beginning with Part 1, Physicians. Section 1 provides the background and description of the board and related professions, including improvements made by the board since the last Sunset Review, such as updating the guidelines for prescribing controlled substances for pain in November 2014, producing 2 public service announcements specific to the opioid overdose prevention issue, offering board meeting participation to consumers via the telephone beginning in May 2014, and completely revamping the board's webpage to make it more user-friendly. This section also contains legislation sponsored by the board and affecting the board since the last Sunset Review, like AB 1838 Bonilla in 2014, when the board co-sponsored legislation that allows graduates of accelerated and competency-based medical school programs be eligible for licensure in California if the program is accredited by an approved agency. Do you have any questions, comments, or suggest changes to Section 1?
Comments?
I just have a comment even before that on page 3 I's where it says forward. Do you really mean forward? As in the forward before you get into the balance of the thing. It's just forward. It's on my page 121. It's just before the table of contents page. Was that a typo? Did you really mean to say forward? Like this is a word before?
Forward. Yes. Okay, we got that.
Trivial, but
Thank
that's
you.
okay.
That's good, Mike. You weren't falling asleep when you read. Okay.
All right.
Please.
He's what? He's up.
I have a comment.
Yes, Dr. Lewis.
On page 32, when we talk about the checkup on your physician, checkup on your doctor campaign, I think I made this comment before regarding whether you can check up on an MD or a DO. I don't know if I mentioned that to someone. Did that get changed or?
So everything that you sent me is not incorporated in
Okay.
this one. So we'll put it in when we go back. So that was one of them to identify that it's only for physicians
Only
on
for
the checkup on
physicians,
your
okay.
doctor. Just so you know, on our website though, when you go there, we have a statement that says if you're looking for an osteopathic physician, go over here. So
Go
and it
elsewhere.
takes them to that link. So
Okay.
So,
Dr. Levine.
so when you clarify that it's only allopathic physicians, rather than just only physicians.
Okay. Any
Okay.
other comments? If not, go ahead. Please.
Moving on, as required in Section 2, it contains results of the performance measures and consumer satisfaction surveys conducted by the Department of Consumer Affairs. But it also contains results for the applicant newsletter and website user survey conducted by the board. The performance measures are posted on the Department of Consumer Affairs website on a quarterly basis. 2015-16 fourth quarter report is found in this section. And the rest of the quarterly reports are provided in Section 12, Attachment M. When the board notifies a consumer that their complaint has been closed, information on how to complete the consumer satisfaction survey is included. However, the board continues to receive a low response rate despite changes for improvement in the survey. Currently, the board receives about 8,000 complaints per fiscal year, and the highest number of responses was 92 in fiscal year 12-13. Do you have any questions, comments, or suggest any changes to Section 2?
Any questions? I still am not sure how you're going to, response rate is bad and the review is bad. So I mean, if that happens in a hospital, usually CMS will cut off 10% of your, I'm just kidding, but 4% of your revenue. That's what their performance measure is. So I'm just trying to see how we can improve response rate at the same time also how we can improve what the satisfaction rate.
So as far as response rate, I'm not sure how we increase that. This does go out to individuals when we close their complaint. Part of the problem that we struggle with when you really look at the information, just board statistics, and this is not just for the medical board, it's also for other boards and other boards around the country, is that we receive approximately, in this last year, we had an increase about 8,600 complaints. And we take action against physicians, about 450 physicians, and about 1,500 of them go to investigation. So those individuals whose complaints get closed, they're really dissatisfied with the board because of the closure of those complaints. And I don't know how you avoid that. You know, most of them in all standard of care cases, that's gone to an expert who's identified that there was no violation, or if it's outside of our jurisdiction, that's a little bit different. But so this is one of the things we struggle with. It seems like from the response rates that we get, it's always from the individuals who are really not happy with the result in that. And so that's one thing that we struggle with no matter what. I think one thing that has happened is when our time increased in our central complaint unit, the fact that the letters were going a significantly time later from when they had filed the complaint, that didn't help matters as well. But that is one thing we struggle with, and you're right, we tried to kind of put a statement in there that the response rate is really low if you're comparing it, but this is something, you know, I'm not sure how we address it other than just saying how low the response rate is to how many we actually get.
Usually I'm just giving my example of a hospital again, when there is a complaint and when that person who is complaining hears from a senior person, like when I call someone and say, I'm so-and-so, I'm chief of surgery, I looked into it and this is what the result is. Even if they're unhappy with the result, they're thrilled that some higher level person called them and explained to them what they did. So I'm just curious if there is anything we can do that way at the medical board level. I mean, they might not be happy with the result, but having someone talk to them rather than sending some letter out might be a way to look at. Dr. Levy.
So the numbers are very large, and the reasons for closure of the complaint very varied. And I'm wondering the extent to which, or the degree to which the responses communicating the closure of the complaint are tailored, how tailored they are to the circumstances, and whether anyone has looked at them from the perspective of tone, degree of specificity, amount of information provided. I'm not sure it'd be practical for somebody to call 8,000 people, but a form letter with, you know, quite honestly, statutorily dictated, I don't know if that's the case, language, you know, certainly, you know, we deal with that in a lot of areas of our lives, whether there's some way of making someone feel like at least they were heard through a formal communication.
And that's one thing we've changed a little bit with Ms. Delp's help, are the letters that go back to them, especially if they had a really in-depth standard of care issue. We've gotten to where now we're using the medical consultant report that comes to us to help write those letters. But those are on those ones that go to a standard of care review. Correct, Christina? Yeah. And so we're looking at those, but I think it's always something, and maybe that's something we could do as a subcommittee of the enforcement committee actually is looking at, hey, maybe you can have a couple members come in and look at our closure letters and identify, you know, is this something you would like to get? You know, maybe we can, you know, look at some consumer input too.
Dr. Bishop.
I think it's pretty well known that people are much more likely to respond negatively when they're unhappy than to respond positively when they are happy. So I might suggest, just in terms of spin on this, to the legislature to point out there aren't very many people responding, so there must be a lot more happy people out there than unhappy.
Dream on, Mike. So go ahead, please.
Okay, continuing with section 3, I'm going to toss it to Ms. Kirkmeyer.
Section 3 provides information on the fiscal part of the board and the staffing. So just in pointing out a couple things, again, as I stated in my report, the board's current reserve will be at 3.6 months reserve, which is below our statutory requirement at the end of this fiscal year of spending as it currently is. This section also, you'll find the expenditures by program component as well as the budget distribution and revenue and reimbursements. There's also information in this section on staffing issues, including vacancy rates, reclassification. And the one thing we really tried to stress in this section is the big press that we've really pushed with the assistance of our deputy director in staff development. And that's something we've really pushed, just providing them more training and providing them with other opportunities for learning aspects, including how to fill out a application, how to do a duty statement, and things like that. So we've kind of beefed up that section. So with that, are there any questions, suggestions, or changes to section 3?
Okay, go ahead. Who has section 4?
Okay, I'll take it back. Section 4 is comprised of the licensing program information and data. This section primarily has information on physicians, but it also discusses information about fictitious name permits, special faculty permits, medical assistants, outpatient surgery setting accreditation, and specialty board certification. With regard to physicians, the board is currently meeting its mandate of informing an applicant within 60 working days of receipt of an application whether that application is complete. Total active licensed physicians has increased from about 135,000 in fiscal year 12-13 to about 142,000 in fiscal year 15-16. This section discusses cycle times, timeframes for application review and licensing, as well as performance barriers and improvements made to the licensing program. School approval process and continuing medical education requirements are also discussed. Do you have any questions, comments, or suggested changes for Section 4?
I
Okay.
actually had a question.
Dr. Bishop.
I'm sorry. I didn't see anything. Is there any data that's available? Because we keep hearing the doom and gloom of the aging physician workforce, and I wonder if you have any data on that to include in the in this section to suggest what our workforce is doing, where we're going with our physicians. Are we replacing the old folks like me that are going to retire? That might be of relevance. Just a thought.
Okay, thank you.
I just have a clarification question. Dr. Bishop, are you like asking for maybe a breakdown by age, which in aggregate form is okay, of our physician population?
It might
That
be
a
it
great
might be an
chart to have.
interesting thing just to show where our physicians are, because every article I read nowadays says physicians are burning out and retiring earlier, and we're losing physicians at least as fast as we're, if not faster than we're replacing them, which might be of some relevance.
Perfect.
Great, thank you. Section 5 is comprised of the enforcement program information and data. Total complaints have increased from 7,459 in fiscal year 12-13 to 8,679 in fiscal year 15-16. Some notable statistics for the board for the last 3 years include filing 960 accusations and/or petitions to revoke probation, obtaining 211 suspension restriction orders, revoking or accepting the surrender of 394 licenses, and placing 441 licensees on probation. Further, the cease practice orders for the first quarter 16-17 already is at 13. This matches the total from fiscal year 15-16. Other noteworthy is the training that enforcement has been doing. Most recently, 2 weeks ago in San Francisco, they held an expert reviewer training. They have also accomplished their goal of administrative law judge training. Some of the topics discussed in the enforcement section is performance targets and expectations, citation and fines, mandatory reporting, and the proactive approach. Do you have any questions, comments, or suggest any changes to Section 5?
Go ahead. Okay.
I just want to add one thing. As some of you'll remember, at the last Sunset Review, some of the things we got hit with was our lack of proactive approach for complaints. And so that's why we really put a lot into this section, because we've actually done a significant amount of work in this area, really, and through, Mr. Serrano's leadership and meeting with some of the legislative offices, we really have pushed on those proactive where we can and where we have the resources to kind of take a more proactive approach, including even if we get newsletters or anything news articles that come in, just forwarding those to our enforcement unit to start a complaint to look into. So we tried to beef up that section.
Yeah, I just want to Kim already mentioned that we will meet with any legislature on the BNP committee, see what their questions are before we go sit in the committee meeting. So we are willing to give them appropriate information so that they know it, rather than try to chastise us publicly.
Okay, moving on to Section 6, which contains the public information policies. This section discusses the board's website and posting of meeting materials and minutes. It provides information on complaint disclosure policies, posting accusations, and disciplinary action in great detail. It lists information that is available to the public, and the board's consumer outreach and education efforts are also discussed in this section. Do you have any questions, comments, or suggested changes for Section 6?
Go ahead, please, next.
In Section 7, it discusses the online practice issues. Online practice, the board actively investigate complaints regarding inappropriate online practice. The board has seen an increase in the number of complaints regarding the use of telehealth. With future advances in technology, including applications available on electronic devices, this will continue to be an issue that the board needs to be vigilant about ensuring consumers are protected. Do you have any questions, comments, or changes to Section 7?
Dr. Lewis.
Why are you calling this section online practice? Is it really just telehealth?
So this is actually based on the questions that came from Senate BMP. So if you look in that section, I believe that's what they call this section. And yeah, I think we're calling it the same thing that they have. I can verify that. Yeah, and so the hard part, I think, for Senate BMP committee is using one set of questions for 37 boards and bureaus. So for other entities, especially like you'll have Contractor State License Board, for example, their issue with online practice regulation is going to be a lot different than what we have. And so this brochure, or this set of questions, goes to all boards. So we're answering it. It's not a big issue for us as it might be for Bureau of Security and Investigative Services, but the name is coming from what the questionnaire is.
The name to be consistent
with the questions, the section. Right. As to where ours would be telehealth.
Dr. Levine.
So thanks for picking that up. I completely missed that. In that case, is it worth somewhere in this section explaining that online practice is a part of, but not the entire universe of telehealth? So just so that there's clarity that telehealth is more than sort of. And online could be a number of different things, including electronic communication as well as video visits, things like that. So just some bridging between their term and education. Thank you.
And just so you know, the question that came, so their section is online practice issues, and it says, discuss the prevalence of online practice and whether there are issues with unlicensed activity. How does the board regulate online practice? How does the board have any plans to regulate internet business practices or believe there is a need to do so? So again, we had to take that question and massage it into medicine. Yeah, we can identify.
Okay, thank you. Okay, we're in Section 8. Section 8 discusses the workforce development and job creation efforts by the board, including efforts to inform potential licensees of the licensing requirements and the licensure process by conducting licensing workshops and licensing fairs, among other things. Do you have any questions or comments or suggestions about Section 8? Okay, moving on to Section 9, current issues. Current issues include the BREEZE system, Consumer Protection Enforcement Initiative regulations, and the uniform standards for substance abuse and licensees. With regard to the uniform standards regulations that were adopted in 2015. However, with the passage of SB 1177 this year, the board will implement a physician health and wellness program. Due to the implementation of this program, the board's uniform standard regulations will need to be amended to accommodate the requirements of this new program. Do you have any questions or comments or suggest any changes to Section 9?
Nope.
Section 10 is the board action in response to prior sunset issues. This is a big chunk of the report. I think it's like 45 pages or something. Because last time there were 39 issues that were addressed in the report. There were 20 that were recommended by the board. And there were 19 committee recommendations or questions or where they asked for additional information. Most of the recommendations have been dealt with a lot of them being approved through legislation through our Sunset Bill. However, there are still a few issues that the board has included additional information in hopes of moving those issues forward in this sunset report. Are there any questions, comments, or suggested changes to section 10?
This is a big one, so I'm just curious if anyone has any. Okay, go ahead, please.
Okay, I'm going to toss it to Kim to tell you about the new issues. I'm sorry, Ms. Kirkmar.
All right, so I'm going to move through each one of these. So most of the new issues were previously approved by the board at the May meeting. However, there were some issues that were added or changes made to the approved issues. So with regard to postgraduate training, so the first one, expiration date of licensees, that was already approved. And then the next one is the postgraduate training. With this regard, the board initially approved the request to increase postgraduate training, I think from 1 to 2 and then 2 to 3 for US and then international. At this point, what we're putting forward in the sunset review is that we require 3 years of postgraduate training no matter what medical school you were the applicant graduated from. In addition, though, one additional caveat that we have to this, and I may have to ask Mr. Warden to come forward, we know that if we do that, we're going to have a training license. So we're going to be working on language where we would have a training license for individuals coming into postgraduate training here in California. They'd have to go through the process. What we have also added to this section on postgraduate training is that if an individual actually has 3 years of postgraduate training, we believe that the current process of the board recognizing medical schools would then in essence should be eliminated. As most of you know, the legislation that has passed in the last several years has authorized individuals who have gone to an unrecognized school to become licensed in California if they've had 10 years in another state or board certified. That already watered down our current recognition process. Then it went a step further and said that if you went to a disapproved school and you practiced for 12 years and you were board certified, you could become licensed in California. Again, weakening our statute to require individuals to go to a board-recognized medical school. So with the caveat that individuals now would be basically having 3 years of postgraduate training, we would like to remove the recognition of medical schools. We would use the World Directory that's from the ECFMG for medical schools that are outside of the United States. They also have an in-depth school recognition process that they're working on, correct, Mr. Warden? What year do they think it's going to be?
They have a pilot right now, and they're expanding it, and it should be functional by 2023.
Okay, so by 2023, which again, it looks like a long time out, but at the same time, they're already starting it. So we would recommend that when we do this, we ask for 3 years of postgraduate and we eliminate the requirement that the California actually has a recognized medical school, and we use the World Directory. Okay, so that's the recommendation.
Dr. Lewis, so that would negate any necessary visits to vet these foreign medical schools if we use the World Directory, because they would have vetted these schools for us and satisfy our qualifications in and requirements.
Yes.
Okay.
Okay.
Good.
All right, then moving on.
Dr. Bishop.
Oh, sorry, Dr. Bishop.
I had, this is a pet project near and dear to my heart. And I just want to raise a scenario because we occasionally see this in our panels. And I think 3 years of postgraduate training is a lot of training, and I think it's a good step. However, as we know in the field, say someone does 3 years of training in a neurosurgery program, then fails out or for whatever reason quits, oftentimes these people end up going into, quote, general practice, which they're probably ill-prepared to do in many ways. So I'd suggest, maybe not this time, but I do strongly suggest that our endpoint be board eligible as a licensing criteria. That's my endpoint. Down the road a piece. I just had to say my piece.
That's good, Mike. That's so much controversy. So, but we're not going there right now. I think one of the problems with any WHO recognized school or world recognized school is that there are a lot of recognizing agencies which approve almost anything, but that's the reason why California had its own accreditation process for the international schools. But I think 3 years of residency in the US takes care of that, so I don't think we'll be worried about that. Because they won't be able to get into residency programs. That's where I think it's going to be. Dr. Levine.
Yeah, and I want, Dr. Bishop has made that point before, and again, that what this does is it puts the burden on the residency programs, accredited, and these have to be accredited residency programs, to ensure that their candidates meet the requirements for practice, and I think that they're in a better position to do that.
Yeah, it is ACGME accredited programs when they apply for California license, MD license. Yeah.
So the next two, I'm not going to go over. Those were both approved, and that's the accredited outpatient surgery settings, both of them. One is for data reporting, that'd be patient encounters and things like that. And the second is to revamp the adverse event reporting. So we'll be holding meetings to see what that language would look like, but those are both things that we think that the legislature needs to help us pass. The consumer notice, again, we have, not going to go over that one. That one was approved. Again, we want to make it to where there's better information on that consumer report. Penalties for 805.01, that was approved. So I'm going to move on to the licensing program enhancements. And as you can see on that page there, these are things that our licensing unit went through and have identified different programs that are no longer necessary. So for example, we have different sections. So 2072 and 2073, these two programs are ones that we no longer utilize. We think that those sections of law should just be repealed. 2104 and 2104.5, there's actually no longer a fifth pathway program, and so there's no need for this the current language. And then in 2115, this is actually another exemption. It's like our 2113 and 2111. However, since it was implemented, we've never done regulations because it's never been asked for. So this is really just what we would consider licensing cleanup. So this is one that we just wanted to change there. The next one, though, is one that actually wasn't brought to the board, and this is one where we're coming to the board to ask for your approval for this one. So this is when an individual, this is a physician re-entry at initial licensure. So this would be an individual who's either coming to California to become initially licensed, who's been out of practice, maybe they were licensed in another state and they haven't been practicing in the last 5 years, or it's an individual who had a license and maybe they let it lapse, they had children, whatever the case may be, and they want to come back from a canceled license to now be licensed in California. The problem is that we tell these individuals you really need to go and you need to have an assessment and you need to go into a training program. Well, they can't go into a training program in California, so it puts them into a really bad position because they have too much postgraduate training. So they can't, come in as a PTAL or as anything like that. Not that they would meet PTAL, but they can't get a license. And so they're in a conundrum. So we're recommending that we actually have a new license type, which would be a limited educational permit, to allow these impacted physicians to come in, get this permit, allow them to go through the training that they need, and then from there get a full and unrestricted license once they've completed that training. So this is, it's to help physicians, but it's also to protect consumers. Okay, no questions on that? Okay.
No, Kim,
yes.
who will be doing that training? Where? And, we have special permits, we got medical school, so I'm just, and the Mexico doctors program, it has to go through medical school, so I'm just curious who will be doing those programs.
I'm gonna have Mr. Warden answer that question. And it really is going to be dependent upon where they can actually get into a program. But
for instance, right now PACE can't offer something like that because they have no mechanism. If we had that mechanism, I can almost guarantee they're going to offer that. Cedars-Sinai also offers physician reentry training, but once again, they can only do it if the physician has a license. And so that poses a problem, and because we can't give them a license. And then when in the past, if you try to they won't be able to get into a residency program because residency programs won't take them. So something that is very similar to this is done in Texas, and it's done by the K-Star group, and they have a limited, what they call a mini residency at the one medical school. hospital at a specific hospital, and then they reevaluate them at that point. And so when they go through, so it'd be something set up that where I can see this being a system where it's limited to certain teaching hospitals that get approval to do that for that specific person. You'd want to ensure that they have the proper training staff to do the training and oversight, because they're going to need the oversight to actually do it. And the idea is there's only one place in the United States that can do that, and that's in Texas. And we need one in California.
So, Mr. Warden, so did Texas get permission from the ACGME? They can do that? Is that, I'm just
It's
curious.
not an ACGME
No, no,
program, but it's somehow it works for them. What they have is it's a very limited program that's through the K-STAR program that's authorized through the legislature, that they allow them to issue this basically it's a 90-day permit to do a retraining of the physician in the skills that they need for the practice they're going to do.
So it's like a learner's permit.
Right.
Yeah, but actually ACGME discourages any kind of non-ACGME accredited fellowships, quote unquote, in an ACGME accredited institution. So I'm just curious, did they apply for, or how does that happen?
I don't know. I mean, I'd have to check on that for you, but it's done with one of the medical schools overseeing it, and then but I don't know how they got around your ACGME question.
I mean,
so.
I think we should get the details. I think it's a great idea. I mean, remember that one of our problems is many times PACE can take care of cognitive skills. PACE cannot take care of any kind of technical skills. So we need a program where you can put these people through maybe 6 months of training again, relearning skills, we call it, not just learning from the books and taking an exam. So I'm just curious if that is, it's a great idea. Just we need to make sure all the requirements are met, including American Board of Medical Specialties, ACGME, and us, Medical Board of California.
Right. It's something that is needed, not just, but here, like I said, Cedars-Sinai does a re-entry program, but the physicians have to have a license, and some of them have a license that just want to be refreshed, but those who let their licenses expire, they don't get to take advantage of it. So.
And again, it's because they can't do hands-on patient care without having some type of license. So we'd have to put some controls around it to where obviously they'd have to have proctoring, over-the-shoulder proctoring. Right. We're not talking about like a practice monitor that checks things. We're talking about proctoring and walking right alongside those individuals. Basically similar to residency.
Similar to residency or one of our special programs that we operate, basically, where we've inspected the facility, ensured they have the proper supervision. We have a couple of hospitals who do that, who have ACGME programs, but they have these also. So.
Any other questions to Mr. Warden?
I had a quick question.
Yeah, Dr. Gola.
Yes, Mr. Warden. He's leaving us, but I wanted to ask, could you give us an example of a hypothetical, just something, and help us, or at least help me understand the benefit to the public and any downstream consequences of such a decision from your desk knowledge?
The benefit to the public is we have doctors who had a license, who sometimes took a break from medicine to raise children, and now their children are older, they want to come back to practice, but they need to freshen their skills. They might have been out of practice 5, 6, 8 years, and they want to come back, but we have no way of bringing them back because we can only get them into an evaluation. So the only way that physician could actually get the skills back is to go to Texas. And that's, there's several physician evaluation programs out there like PACE and CPEP, but only one of them offers the hands-on skills in an actual setting where they can actually see them in an actual day-to-day practice. To me, that's a benefit because we've had that happen where we've had applicants who did try to raise their, they did raise their children for a while and wanted to come back to practice, and they couldn't. And then when they try to find some place that they can think that will let them work, the only way they can't get in because they don't have a license, or the only other option we have is a probation license, which is not the right way to go for these individuals. So they didn't do anything wrong. They just need some training or refreshing to
Right
get
now,
their skills.
all we have is PACE to send them to, and that's only to just go through the PACE assessment. Then if they recommended any further training on that for that individual, they would be stuck. They wouldn't be able to complete it.
And that requires the license. And so unless the individual chose K-Star to begin with to go to, that's the only, they would have to then go to K-Star if they couldn't get the training. And I think that's not fair to the physicians who haven't been out of practice very long, but still need to have refreshing their skills, but it also sends doctors away. So we don't really need to send qualified doctors away who just need to have their skills refreshed.
And one last question, what's your sense of who are these doctors? Are these surgeons, are these neurologists? Do you have a data set?
We've had some from just about every specialty. So we've had pediatricians, we've had family medicine, we've had surgeons, and so it's just depends. We also have some doctors who decided to retire and then they got bored and they wanted to come back, but they waited. They let their license expire. And they can't get back in. And that's the board has seen that happen a few times, and sometimes when you put a probation license, give them a probation license where they have to have 25 assists and 25 or 50, depending on their specialty, they have a hard time trying to meet that. And so because people don't want to take the time to train them because they're taken away from their practice. And if you had something set up so where they could actually have something that would be sort of run for them for that specific purpose, it would be easier. And that's why K-Star is sort of successful in Texas.
In addition, Kurt, people who are on probation can't get privileges at the facilities where they could do the procedures. So they're in catch-22.
Any other questions? If not, thank you, Mr. Warden. Go ahead, please.
Okay, so the HPEF board membership, I think that's been discussed, and that's just to get our board back on that foundation's board. Then the next one that we added in here was the Board of Podiatric Medicine. As you remember, we brought this forward as a legislative proposal at the end of October of 2015. That bill didn't go through, but it was very clear from Senator Hill at the meeting where this bill didn't go through that this would be part of the medical board sunset, and hence we put it in here to show how important it is for us that we get that changed.
Kim, I just want to remind the board, we means Medical Board of California contributes through physician license majority of the money for the scholarship fund. And we don't have any membership right now. That makes no sense to us, so.
So the next one is actually one, again, that we didn't bring to the board, but we think it's important to put in the board sunset, and that's the board panel membership. So currently, the way statute is constructed, we've actually put ourselves into a catch-22. So what happened is when the law went in, when we moved down to 15 members, and we still have 2 panels, what the law says is that each panel should be made up of 7 members, and that the board president, if there's a full complement of members, cannot sit on a panel. That's what the law said. But then there's another section of law that says that you cannot have more public members than physician members on a panel. So when the board president, if we had a full complement today, Dr. Gonadev can't sit on a panel, and I would end up with one panel made up of 4 public members and 7 physician members. Three physician members, right? Which is not my strong suit, I guess. Huh? But anyway, it sets it up as basically we're in conflict of the law, and I'd have to have a public member sit out, and I don't want to do that. We want to have 7-member panels. So what we would like to do is change the law to take out the language that says that the board president cannot sit on a panel. It just doesn't make any sense. So that's what that one entails. The next one is the enforcement enhancements. We had talked about this briefly, but we didn't give the full detail of what the changes that we were requesting. This, on the page 213 through 215, it lays that out. The first one is that we believe that for sexual offenses, we've written this to where individuals who have to register as a sex offender right now, they still have to go through the entire filing of an accusation, through the disciplinary process, through the hearing, and during that time, obviously, we could ask for a suspension, but we believe when the law was written to state that they have to have a prompt revocation, it meant a prompt revocation. And so this section would change 2232 to basically put that prompt revocation in and let the individual then come back through a separate hearing process, different than anything else. I don't think anybody would disagree that somebody that has to register should be promptly revoked. The next section is 2225, and this pertains to the section for medical records, requesting medical records. And Carrie, do you mind talking about this one? And this was because of a recent case, so we want to make sure our bases are covered.
Yeah, this was prompted because of a recent case where a patient made a complaint and authorized the board to obtain records, and the physician may have had some influence over the patient, suggesting that he would not continue to provide care and treatment and medication, and the patient withdrew the authorization. The board proceeded with a subpoena to get the records, and the patient and the physician objected to the board being able to get the records. The AG's office took a subpoena enforcement action, and the trial court said that the physician needed to turn over the records. And the physician took it up on appeal, and the appellate court said that because this physician was a psychiatrist, that psychiatrist, psychologist, patient privilege trumped the board's ability to get the records where the patient objected. And so it was very troubling. Luckily, there was a way to maneuver around this. The physician surrendered his license because of a different action. The matter became moot, and so the AG's office was able to get the appellate court to just dismiss the appeal as moot following a reconsideration. And so we want the law to be changed so that it's very clear. We think it's already covered, but just so that there's no question, and this can't be argued again, that our section that allows us to get these records, make it clear that this includes psychiatry records as well as the other records we can obtain, because otherwise it'll create a safe haven for unscrupulous and incompetent physicians who are inappropriately prescribing or otherwise treating inappropriately.
Better wording is mental health or behavioral health records rather than psychiatry. So, any questions on this side? Anybody here?
And then the last one is just a change to the government code section. It states specifically to an accusation in that section pertaining to an interim suspension order, and it should be the filing of an accusation or a petition to revoke probation. And just to let you know, we've worked with the Attorney General's office and really appreciate Ms. Castro's staff for helping us in these enforcement enhancements that we're requesting. So that concludes the new section, new issues. So hopefully, if everybody's good with that, we'll move on to part 2. Okay.
Just one comment. It would be helpful, I suspect, for any future reviewers, if on the front page of the section, there's a page number by each item, So it's just easier to track back and
Yep.
forth.
You, Kim, before we leave this section, I just,
Reading on the computer, actually, you have a sections here, so you can easily click on the section. But anyway, go ahead, please.
one of the,
Yes,
one of the threads that,
Certainly.
that wends its way through this is just the increase in work, increase of licensees, increase of licenses renewed, increase in telepractice, increase. There's been a lot of workload and some mitigation in hiring, and just presents a good opportunity to thank everyone for their very hard work on this.
Thank you. Really, staff appreciates it a lot. So.
Definitely. Okay, so moving on to part two, and then I'll kick it back to Ms. Robinson over there. So part two is the midwifery program. This includes just background and description of the program, the fiscal and staff issues, licensing program, and enforcement program. The total active licensed midwives has increased from 297 to 365. And the one thing to point out is that in January of 2014, the scope of licensed midwives was significantly changed when Assembly Bill 1308 eliminated the requirement for physician supervision and authorized the licensed midwife to attend cases of normal birth as specified. It also authorized the licensed midwife to directly obtain supplies and devices, obtain and administer drugs and diagnostic tests, order testing, and receive reports that are necessary to the practice of midwifery. The one thing that I would like the members' input on, and I'm sure I'll have public comment on this at the end as well, is the section that starts on page 226. This is the enforcement program section. One other thing that happened with that bill was that it required a hospital reporting form of a transfer to the hospital and a planned home birth. And what we did is we considered that for the aspect of how we gather data and how we have input this information into our system. We've considered that a complaint because it's a mandated report, just like a physician would get a mandated report for a death that happened outside of a hospital. They have a reporting form like that. However, as we've footnoted it, and I'd kind of like to get the members' input on this, you can see there we have an asterisk. It shows the complaints went from 25 to 152 and 158. And we're wondering if we should pull those out and make its own separate chart for the hospital reporting form to where they don't look like complaints. Because although while we may consider them and look at them for a complaint, and we may then further progress to the investigation stage on some of them, we don't want it to look like, oh my gosh, all of a sudden we have 125 more complaints that came in on licensed midwives. So I'd just like to get a little feedback from the board. If everybody agrees, I think we'll pull that out and put it in its own separate chart.
Dr. Levine.
And call it unplanned admissions or?
Yeah, the form has its own name, so we can just call it hospital reporting form for unplanned or planned home births that were transferred to the hospital. The form has a long convoluted name, but we'll.
My concern is this, Kim, is that if you consider that as a complaint, someone there might consider not sending them in time to hospital. I would rather prefer people be on the safe side and send them to hospital rather than the other way around. So it should not be considered as a complaint.
Absolutely.
It's
So
just
we'll pull those
it's
out.
just an event. It's
Yeah.
like outpatient surgery center. If somebody has a lot of pain, they transfer them to a hospital. That's not as below the standard care. It happens often, but if there is a complication, then it's below the standard of care.
And we look at those, each one that comes in, to identify whether there is something that we need to further investigate. But yeah, we just wanted feedback from the board because we are treating them a little bit different than physicians, but I think in this case it's much more.
And we should also let them know that it's encouraged if they have any doubt, because what we're trying to do is safety of the mother and the child. That's about it, more than anything else.
Okay, then moving on. Ms. Rupp.
Okay, part 3 is the polysomnographic program. It includes background and description of the program, as well as licensing and enforcement program information. In April 2012, the board began accepting applications for the polysomnographic program. The program registers individuals as polysomnographic trainees, technicians, and technologists. Initially, the board received an influx of applications. During the first 2 years, there was a steady increase in the number of applications received. Since that time, the number of applications received has leveled off and has maintained a consistent volume. Currently, active polysomnographic registrations for fiscal year 15-16 were 60 trainees, 79 technicians, and 572 technologists. Do you have any questions, comments, or suggested changes to the polysomnographic program report?
Does that program financially self-supporting?
No.
No, no,
Yeah, that's why there's no
I get
fiscal.
that. What I'm asking is, from the license fee you get from that program, does it support the cost what that program incurs?
We'd have to go back and look at that and bring it back to the board because they do have a registration fee and that's all in there. We'd have to pull it because we actually did, when we put them in, we did keep them separate. So we actually do have their funding separate and their expenditures separate, so we can let you know at the next meeting.
Okay, and part 4 is the research psychoanalyst. It includes background and description information on licensing and enforcement. The legislature enacted the regulation of research psychoanalysts under the board in 1977. The total active research psychoanalyst registrations have decreased from 91 in fiscal year 12-13 to 82 in fiscal year 15-16. Any questions, comments about the?
You can educate us what exactly they do. I think we'll appreciate it. So, you know what exactly is the program is? I know there are these side programs in medical board. We always wonder what they are, and this is one. Even I don't have much awareness what it does. So.
Yeah, I used to issue these registrations, and I still don't know what they do.
So these are individuals that can engage in psychoanalysis as an adjunct to teaching, training, or research. I'm just reading from the report just so you know it's easier for me. An adjunct means that a research psychoanalyst may not render psychoanalytical services on a fee-for-service basis for more than an average of 1/3 of his or her total professional time, including time spent in practice, teaching, training, or research. Such teaching, training, or research shall be the primary activity of the research psychoanalyst. And it talks about their requirements, but really it's a lot of research, as Kurt always is telling me. That's what they do.
Yeah, and there's students as well as graduates, so there's 2 different registrations.
And not a lot of enforcement activity as well.
Nope.
Very small. But I believe that important to be registered because there is that temptation in that field, so.
Okay, go ahead, please.
Okay, and lastly, it's just the section 12 that contains the attachments. That's it.
So at this point, we would actually ask for probably a motion to approve the report with any suggested amendments. And then because the amendments weren't too significant, I have a couple from Dr. Lewis that he has actually forwarded me an email that we will write in as well. And again, they're just minor technical cleanup. Then we would recommend that the board delegate to the board president and vice president the ability to sign off on the final report to submit it on time by December 1st.
So moved.
Can we also authorize staff to make any non-substantive
Yes.
changes, like typos and grammar issues that we catch?
Yes, like forward and forward.
Okay, any comments from the board? Dr. Levine.
Having had to lead the last sunset review, this is really fabulous work. Staff it's clear, it's thoughtful, it's organized, and it really represents all the work that's been done in the last 4 years, and really credit to the staff for not just the report, but for everything that enabled us to get to this point where we walk into that hearing with our heads held high.
I can tell you, Dr. Levine, that after looking at what happened, we're so thankful to you. I had no intention of sitting there and taking abuse. So let me be very clear. I absolutely have no intention of taking abuse. So
I wasn't
Any other comments? If not, public comments, we got Marian Hollingsworth. Let me get that.
Good afternoon. My name is Marian Hollingsworth, and I'm here on behalf of the Consumers Union Safe Patient Project. We recommend the medical board change its own policies or request that the legislature make changes in state law to address the following important issues as part of the sunset review process. We recommend amendments to the statute of limitations on filing complaints against doctors. The state law governing the medical board's statute of limitations is convoluted, unfair, and creates barriers to patients' ability to participate in a fair complaint process. Often patients who have been harmed by physicians don't know where to file complaints, or there is a delay due to the patient recovering from the actual harm. The statute of limitations is 7 years from the date of the event leading to a person's complaint. However, there is another conflicting condition. Once the medical board learns of an incident from anyone, not necessarily from the patient, the statute of limitations allows only 3 years until accusation. We recommend that the medical board should be required to notify patients when another party files a complaint about the patient's case. Also, when the statute of limitations has run, even in cases where the medical board has found an extreme departure of the standard of care, those complaints can be closed. This leaves the physicians who have violated their licensing standards to continue to practice without discipline. According to the draft Sunset Review report in 2015-2016, the medical board was forced to close more than 150 cases because the statute of limitations had run. The medical board should recommend the statute of limitations be changed to provide a fair and predictable process for patients who wish to file complaints. Thank you.
Thank you. Lisa McGifford.
I'm Lisa McGifford, and speaking on behalf of Consumers Union Safe Patient Project, I would like to speak on recommendations on the outpatient surgery centers. We recommend that these surgery centers or surgery settings under your purview be required to report a standard and robust set of data to the Office of Statewide Health Planning and Development. As most of you know, these settings are doing hundreds of thousands of surgeries, and there's no data collected to track what those surgeries are. That data used to be collected, but due to a 2007 court decision, the data collection was removed. So we encourage you to include that in your recommendations. We also outpatient settings are required by law to report adverse events to the medical board, and it authorizes the medical board to fine physicians who fail to report these adverse events in a timely manner. We recommend that the website listing for each outpatient surgery setting include the adverse events reports from that setting and any fines assessed against that outpatient setting, so that all the information is there in one place. Current law says that consumers and journalists can get adverse event information on hospitals by request, and we have used that law to get such information. We recommend the medical board do the same regarding accredited outpatient surgery settings, providing adverse event information to consumer groups and journalists who ask for it. A new issue, not connected with outpatient surgical centers, is in the Sunset report, the staff is recommending that it be given fining authority for entities that fail to make required 805 reports of peer review findings, and we strongly support that recommendation and urge you to pursue this fining authority to increase the likelihood that you will be notified early in the case of such findings. Thank you.
Thank you. Edward Hollingsworth.
My name's Edward Hollingsworth. I'm here on behalf of the Consumers Union Safe Patient Project. And we recommend the medical board change its own policies or request that the legislature make changes in state law to address the following important issues in the sunset review process. Improved outreach to patients by revising signs on doctors' offices. Currently, doctors are required to post a sign in their offices in all places where they practice. The current sign says, "Notice to consumers. Medical doctors are licensed and regulated by the Medical Board of California." It gives the phone number and web address. The board's draft sunset review report recommends to change the sign. Now, we recommend to revise the sign to clearly state that the medical board is where patients may file complaints against a doctor and look up their doctor's history. Now, we recommend the medical board seek authority to post malpractice information on the physician Breeze profile. In 2014, legislation was passed to ensure public access to disciplinary and other related information by removing the requirement that this information be removed from the website after 10 years. However, the legislation has also ended up significantly reducing the medical malpractice information available to the public via the internet. Now, the only purpose for this was to create an extra hurdle for the public to access this information, which is unwarranted because this continues to be public information. Now, we recommend that the MBC seek changes to state law to require all medical malpractice information reported to the board that is public information by law be indefinitely included on each Breeze physician profile. Okay, thank you.
Thank you.
Karen Ehrlich, licensed midwife. I want to thank the medical board recognition that the out-of-hospital transfer forms being looked at as complaints in your system is inappropriate. I know from the midwives who were a part of the negotiation for AB 1308 that authorized the reporting of the hospital transfer information, that this was for information only. It was for data. It was never meant to be a backdoor to investigations, which is how it has come to be seen by too many of the midwives in California. So I am really gratified to hear that you are recognizing this, and I hope that indeed we can get a good clarity on this soon, that this is supposed to be data only. There's no question that anybody who has a complaint against a midwife, whether that is a hospital or a doctor or a citizen or a consumer, can draw up a complaint and make it be a complaint. Unfortunately, too often the hospital transfer forms are filled in by clerks or filled in by people who don't know the history of what has been going on in the births. Sometimes the midwives fill in a portion of it first so that that clarity is stronger. But that is not across the board happening. So I really I'm so glad that this is being a part of the Sunset Review. Thank you so much for that. And I hope we can move forward to making it even stronger. Thank you.
Thank you. Any other public comment? Any comment on the phone?
We have a question from Eric Andrews. Please go ahead.
Go ahead, Mr. Andrews.
Hello, board, and all my advocate friends in the audience. My name is Eric Andrus. I'm calling from Los Angeles. I'd like to comment on the survey that you supposedly sent out to people who have had their complaints closed. My disabled sister died of medical errors, and I filed a complaint with the medical board. After 6 months of hearing nothing at all, they closed the complaint. I found out by calling the hospital that the medical board had not given a certified copy of her medical record from the hospital. Instead, they used records the doctor had sent in as a requirement to report his malpractice lawsuit settlement with me. I complained to Christina Delp, who reopened the case, got the certified medical records, supposedly sent it to one of your so-called medical experts, and then the case was immediately closed again. It makes one wonder who these experts are and what their qualifications are. Doesn't the public have a right to know who's helping to cause these cases to be closed? What if the expert is wrong? I filed a Public Records Act request to get a copy of the complaint, or at least the portions that are public. And Carrie Webb denied the request quoting GC 6254F, which is an exemption that can only be used if you explain to the requester why the information should be made public. She has continually broken the law and not provided that information. I received 2 letters closing my complaint, and neither time did I receive information about a survey. While I was on hold, I contacted another victim and asked them if they got information on the survey, and they said no. I think you probably really don't want to know what the citizens you're refusing to protect think, as clearly all the closed cases aren't hearing about the survey. How many people have not received information on the surveys, and you think they're just not answering? I'll be calling back tomorrow with more information on how Carrie Webb and Christina Delph have broken the law multiple times with the Public Records Act. I wouldn't walk into the sunset review with your heads held all that high. Thank you.
Thank you, Mr. Andrews. Any other comments on the phone?
We have no more questions in queue.
Thank you. So we have a motion made and seconded. Can we have a roll call, please?
Dr. Bolot?
Aye.
Dr. Bishop?
Aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Yes.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Aye.
Dr. Gonadev?
Aye. Motion passes. Okay, the big one is done. You must be all hungry. We'll try to finish fast. Our next agenda item is item 10, update on the demographic study. Ms. Robinson.
I provided an update on the demographic study at the July Enforcement Committee meeting. It was reported that board staff expected the California Research Bureau to present the study findings at this board meeting. On September 14th, board staff again met with Patrick, the senior policy analyst at the California Research Bureau, who is conducting the study. At that meeting, Patrick requested additional data. Board staff provided the data on September 28th, and Patrick is now in the process of finalizing the report. Most recently, on October 21st, Patrick notified me that the draft report is complete and is going through the final internal peer review and should be ready for board review in early November. It is now anticipated that the report will be presented at the January board meeting in Sacramento, provided he's available, because he hasn't firmly said yes, but we're hoping that's what's going to happen. That concludes my demographic study update. Are there any questions?
Yeah, thank you, Ms. Robinson. Any questions to Ms. Robinson? Okay. Any comments from the audience? Any comments on the phone?
No one in queue.
Thank you. Next item is item number 11, Special Faculty Permit Committee, Dr. Bolot.
Yes, thank you. I don't know how I'm going to do this without you, Kurt, in the future, but here we go. So the Special Faculty Permit Review Committee, as described in your board packet, Board BRD 11-1 through 3, held a teleconference meeting on September 29th, 2016, and reviewed the outcome of the Special Faculty Permit Survey that was presented to the Licensing Committee at the May 2016 Licensing Committee. The committee determined the Special Faculty Permit Program did not need any changes at that time. The committee also reviewed one application for an applicant from the University of California, San Francisco. Going to be 3 sections here. First, Dr. Sano's specialty. Dr. Sano's area of expertise is pediatric cardiac surgery, and his qualifications: he attended medical school and postgraduate training. All that information is on BRD 11-2 through 3 of your packet. The following are some of the positions Dr. Sano has held. Those include Professor and Chairman of the Department of Cardiovascular Surgery at Okayama University Medical School in Okayama, Japan. A Professor, Functional Physiology, Biophysiological Science, Okayama University Graduate School of Medicine and Dentistry, as well as Chairman, Department of Cardiovascular Surgery at Okayama University Hospital in Okayama, Japan. He also was vice president of the Okayama University Hospital in Japan and professor of functional physiology, biophysiology science at the Graduate Medical School and dentistry and pharmaceutical science chair. Dr. Sano has extensive experience in the surgical care of patients with life-threatening cardiac abnormalities and is regarded internationally as a leader in the field and a pioneer in the development of new surgical techniques. Dr. Sano is responsible for transforming Okayama University Medical School cardiovascular program into one of the leading pediatric cardiac surgery programs in Japan, performing over 500 cases per year. He also teaches local surgeons in the pediatric cardiac surgery procedures. Further, Dr. Sano has given approximately 150 invited lectures internationally and has participated in many surgical symposia in Asia, Europe, and the United States. Dr. Sano is internationally renowned for his contributions to the surgical treatment of congenital heart disease, including the development of the Sano procedure for hypoplastic left heart syndrome. Dr. Sano has performed more than 7,000 pediatric cardiac surgeries in Japan and has pioneered research on cardiac regeneration therapy. Dr. Sano and his research team have developed a progenitor cell therapy for patients with single ventricle heart failure. Now, what will be Dr. Sano's UCSF responsibilities? He will hold a full-time faculty appointment as a professor of surgery at UCSF, if approved, for the special faculty permit appointment by the board. Dr. Sano will engage in the practice of pediatric cardiac surgery at UCSF and UCSF-affiliated hospitals, teaching cardiothoracic surgery fellows, participating in teaching conferences, and resident rounding. Dr. Sano further will serve as the PI or principal investigator of a multi-center trial of stem cell autotransplants in pediatric patients at UCSF. And I would make the following motion to our board, that the board approves Dr. Sunjay Sano for a Business and Professions Code Section 2168.1A1B special faculty permit appointment at the University of California, San Francisco. That concludes my report.
Thank you. Do we have a second?
Second.
Any comments from the board? Any comments from public? Any comments on the phone?
We have no one in queue.
Thank you, Ms. Stoof. Roll call, please.
Dr. Bolat?
Aye.
Dr. Bishop? Aye. Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Wormuth?
Aye.
Dr. Gonadev?
Aye.
Thank you.
Thank you. Thank you, Dr. Bola. Next item is item 12, update from the Application Review and Special Program Committee. Dr. Bishop.
Thank you. The Application Review and Special Programs Committee met today at 1:30. We reviewed 3 physician and surgeon applicants. Myself and Ms. Lawson were present during the Application Review and Special Programs Committee establishing a quorum for the meeting. Mr. Warden presented the 3 applicants to the Application Review and Special Programs Committee. The Application Review and Special Programs Committee made recommendations to the Chief of Licensing for each of the applicants. The meeting was then adjourned.
Thank you, Dr. Bishop. Any questions to Dr. Bishop from board? Any public comment? Comments on the phone?
No one in queue.
Thank you. That concludes item 12. We'll move to item number 13, outreach campaign. Dr. Hawkins.
Thank you. I'd like to provide an update on the Checkup on Your Doctor License campaign. Please turn to tab 13 in your board packets. I'm pleased to report that the board's Office of Public Affairs has continued its work on this outreach campaign since the last board meeting and has continued success in its endeavors. As we mentioned in that last update to the board, the Checkup on Your Doctor's License tutorial was completed and posted on the board's website as well as on YouTube. This tutorial walks the patient through the steps needed to check on a physician's license. The Spanish version of this tutorial has now also been completed and now posted on the board website and on YouTube.
The Check Up on Your Doctor's License brochure was also translated into Spanish and is available on the board's website and will be provided at outreach events along with the English version. A message encouraging state employees, vendors, and contractors to check on your doctor's license appeared at the bottom of all state warrants for June 2016, reaching 439,916 individuals. The board has made arrangements to have another global message like this on the March 1st, 2017 state warrants, in addition to a flyer that will be placed in the March 31st, 2017 state warrants, because March is National Consumer Protection Month. CalPERS ran a short article in the board's outreach campaign in its Perspective newsletter, Fall 2016 version, which is delivered to members' homes and is available on the intranet, reaching 1.7 million members. A copy of the article is in your board packet on page BRD 13-6 and 7. CalPERS will be posting a bulletin on its intranet site, reaching 2,900 CalPERS employees. CalPERS also provided a link to the board's website on its open enrollment page from September through the end of October 2016. CalStrans ran a news brief on the Check Up on Your Doctor campaign in their Retired Educator publication in the summer 2016 edition. A similar article ran in their Connection publication in the fall 2016 issue. Together, both publications have potential reaching 900,000 current and retired California teachers. A copy of the news brief can be found in your board packet on page BRD 13-8. I'm very pleased with the board's work on this outreach campaign. Staff will continue to reach out to counties, cities, unions, and other large community organizations and legislative offices on this campaign. Now that the tutorial is completed, board staff will begin working on a public service announcement for this outreach campaign. I hope to have that completed by the next board meeting. This concludes my update.
Thank you, Dr. Hawkins. Ms. Kirschmeyer.
And I wanted to just take this opportunity to just add one thing to the really update on the Public Outreach Committee. This is actually the, I think it's the Santa Clara County, this is the Santa Clara County Medical Association magazine here that they do. And they have been reprinting our articles for the last several issues. So this is one, our FAQs on the CARES was printed in there. It also has our advertising. We did a whole spreadsheet on advertising questions for physicians. And then they did our news to use. And so this has been happening for those last several issues of this magazine. And I just, again, just building those relationships so we can get information out in even odd ways that we would never even think that they would just take our newsletter and start reprinting our articles. So just wanted to bring that to the members' attention as well.
Dr. Lewis, you want to see. Any questions from the board? Dr. Levine.
So the CalPERS, this is very nice, the CalPERS thing, and I wonder if it might be worth a conversation with the head of CAP, California Association of Health Plans, about the commercial plans in the state in their materials, including this kind of information for potential enrollees.
It's good. We're hitting both public on the issues and also the doctors on the issues. That's what we need to do. Any public comment? Any comments on the phone?
We have no questions from the phone lines.
Thank you. Thank you, Dr. Hawkins. Next item is agenda item 14, update on the Physician Assistant Board. Dr. Bishop.
Thank you again. I'd like to report on the Physician Assistant Board activities since the last meeting of the Medical Board in October of 2015. That's a typo here, I apologize. Since the last Medical Board meeting. The Physician Assistant Board held its quarterly meeting this past Monday, October 24th in Anaheim. First, a word of thanks. The PA Board would like to thank Ramona Carrasco of the Medical Board's Enforcement Program, and indeed all of the Medical Board staff for their assistance, specifically provision of a presentation on the recruitment and training of medical consultants. It was brought to the attention of the members that consultants must have a valid license, no recent complaints, and be board certified. The PA Board will be researching the question of, should a consultant performing the initial review of a complaint be a PA. We would like to acknowledge Mr. Robert Sachs for being elected again President of the PA Board for 2017, and Mr. Jed Grant for being elected Vice President for 2017. And being a member of that board, I think that's a very strong, positive thing. With respect to legislation and regulations, first, the board discussed State Bill 1083 Pavely that is to be implemented by January 1st, 2017. This bill allows PAs to sign disability forms for EDD. It was mentioned that this bill has been implemented and PAs can now register online. Second, the board discussed the law which allows the board to establish by regulation a retired status for PAs who are not actively engaged in practice as a PA or any other activity that requires them to be licensed by the board. The board currently does not have a retired status for physician assistants. The board members approved the proposed language for retired status, and staff was instructed to move forward with the regulatory process. Third, the board discussed possible action to amend regulations regarding the license renewal and the reporting of infractions. During a previous meeting, concerns were raised whether the $300 threshold for reporting infractions was too low. The board has now approved a proposed language to move forward with the regulatory process to increase the threshold from $300 to $500. The Education Workforce Development Advisory Committee discussed the possibility of possible legislation to offer tax deductions for preceptors. It was noted that California has currently 13 accredited PA programs. The national average of preceptors who are required for teaching the students in these programs who are paid for instructing students is 33%. But in California, this is much less. In fact, most programs in California do not pay preceptors. Since this is a very intensive job for these preceptors, it's difficult sometimes to recruit them. Georgia recently has passed legislation that provides a $1,000 incentive per student up to 2 students per year for a $10,000 tax savings to preceptors. Following a lengthy discussion between board members and stakeholders, a motion was unanimously approved to contact the Senate Select Committee on Healthcare Workforce regarding tax deductions for preceptors. The last item is that the board currently charges a fee of $25 for the initial application of a physician assistant. It was determined that at the next board meeting, staff would provide the members with an analysis to show how much it actually costs to process an initial application. Since the fees are currently in statute, at the next meeting a discussion will take place regarding the possibility of changing the statute to increase the initial license application fee. This concludes my report. Are there any questions?
Thank you, Dr. Bishop. I'm not sure where the tax deduction will go. We tried that when we provide free care. We provide care to Medi-Cal, but anyway, nice thought. Any questions to Dr. Bishop?
As a movie put it, hope floats.
Any public comment? Any comments on the phone?
We have no questions from the phone line.
Thank you. I actually asked Ms. Kirschmeyer if we can take some of the items from tomorrow. She said, no, it's like airplanes. They can't leave early. They can be delayed all the time. So we can't take tomorrow's items, so this will adjourn the meeting today.